For judgment item number 1, CRA 181 of 2000 with CRA 192 of 2000.
The appeal is allowed. The accused shall acquit.
For judgment item number 2, WA 348 of 2014.
The writ appeal is dismissed.
Old matter item number 3.
My lord, my lord, here this case, though it's a volume is bulky, but matter is very simple. The petitioner had got land in Boinagar, in Bhubaneswar, and government wanted that particular land. So government in exchange allotted another piece of land, and there is a deed of exchange was executed between the parties, government and the petitioner number 1. But thereafter, when the petitioner number 1 wanted to have the possession of the property, the possession could not be handed over because of obstructions in the land. So if I requested for
Mr. Dayananda Mahapatra was to submit a report.
Yes,
What
that report is there.
the report is there, and also the
Page
government.
4 of the report. Page 4 of the report.
My lord, in the second matter I am appearing.
My lord,
Page 4 of the report.
Yes,
my lord,
para
page
8.
4 of the,
In
relevant
course of measurement, the followings were found out.
My lord, so far as petitioner is concerned, relevant para is para 10. The other reports is related to other writ application, my lord. But para 10, my lord, page 7. So far as present petitioner is concerned, my lord, para 10. Present writ petition is concerned. My lord, para 10 and 11, they say that under the particular land, the pipeline of the PSD and the water supply line, and also electricity line by OPTCL and BSNL, they have laid cables, and also electrical tower and live wire laid over the part of the allotted land. My lord, the government also has submitted a report pursuant to Lordship's direction. Government has also said in the affidavit report, Lordship will see, last occasion Lordship directed the government to serve a copy on me, because they have served a copy on me. They have also categorically said that electric substations made by OPTCL and there is a electricity substation is there over the land. But, and I have also filed a photograph in my affidavit that they have also installed switch box. OPTCL has also fixed switch box. The affidavit I have filed, my lord. Affidavit is also the transformer and switch two switch boxes. So naturally,
May I submit one thing to my lord?
Yes.
Your lordship may kindly have a glance at order dated 22/12/2017.
Yes.
In this order, two things have happened in the meanwhile. Advocate Commissioner submitted the report, and the RI of GA department, he has also submitted a field report as per the direction of the court. Now I suggest to your lordship, subject to your lordship's acceptance, there are two materials available before the court, one of the GA report and the Advocate Commissioner's report. Your lordship may direct the GA authority to comprehensively consider both the reports and take suitable action in accordance with law in terms of the reports. Because they are fighting with each other, that he is encroaching, he is not encroaching, all these things. There are two reports, and both are apparently independent report. One is Amin's report, another is Advocate. There is no discrepancy in both the reports as on the face of the records. So your lordship may direct the director of estate or the GA department to take suitable action on the in terms of both the reports. I think neither party will be prejudiced by that.
Basically, demarcate the plots.
Yes.
No, only one aspect of Lordship kindly consider. But both the reports clearly say that there is obstruction because the electrical substation in transformer.
If there is there, then GA department will take action for eviction of the encroachers.
Report also it is there. So that land certainly is not, but that land is not fit for construction. The land is totally blocked, my lord, by the OPTCL and also on the under the ground, the BSNL pipeline, the PSG pipeline, all these have been laid down. These things are there because commissioner has inspected the premises with the presence of the GA department, my lord, GA department omits.
For the last 11 years, these litigations are running.
No, what is your suggestion, Mr. Mishra? You want this plot of land? You don't want.
My prayer is to allot another land.
So that you make that representation. Now that the reports have come out clearly, you make a representation.
No, my lord, I have already made a representation. I will
ask him to consider it then.
Then your lordship may record that he abandoned
When
the
did he
claim
make
over
a
the
representation, sir?
That is in page 37, annexure 8.
Annexure A.
Annexure 8. They have to take, they have to.
And all these exercise become futile.
Futile.
For last 10 years, everything at their instance, we are doing all these things.
Yes.
My lord, what I humbly submit, my lord, is I have, as a matter of fact, I have entitled to this, because they have taken my land and they have the land they have allotted to me. That is not use it. So that is the reason I have put right. Your lordship,
The whole exercise.
We will make it clear if as per the commissioner's report, if there is any encroachment or some
there is it.
obstructions, that will be taken care of by the GA department. But if he doesn't want to claim that particular land, then he must come forward.
I do not. The problem is that I have got my claim, my lord. The claim is the land is a very valuable land, but I cannot. How can I use the land when
Mr. Mishra, you have to be clear.
Yes.
Do you want this land or you don't want this land? If you say no, this doesn't suit your purpose. No, 1 minute. If you say it does not suit your purpose, we'll record that.
My lord, all the encroachments removed.
Everything, sir, you can have 10,000 conditions. The only question is,
no condition.
you want this land or you don't want the land?
No, it is not a condition, my lord. It is a matter on record, my lord. Not a condition. If a land is allotted to me and land is full of obstructions by the OPTCL, by the different departments, then how can they got my land free from all encumbrances? They got my land free from all encumbrances. It's not that they are doing it as a matter of charity.
That is why my response submission is that your
department
to act in terms of both the reports and to ensure that the land allotted to the petitioner is given in accordance with the order.
Proper alternative land will be also given to the petitioner.
Again, you are coming forward with an alternative.
Naturally.
So you must stick to one. Either you say that I am interested to take this land or any alternative land.
I am ready to take this land. They must remove the encroachment by OPTCL.
That is, according to you, there is encroachment. What is according to
the records, my lord.
Then if it is according to record, it will be taken care of.
According to the records. According to the records, OPTCL has fixed up transformer line. That is there on record, my lord. And switch boxes have there. That is on record, my lord. So cables have been laid down onto the land by the PSD, by the BSNL, by electricity department. All the cables are when cables are there under the I cannot make any construction over the land. That is all these records, documents are there on record, my lord. That is the reason I say that they have to either they can remove all these things and they allot give the land to me, or they will enter alternative land. That is the only case. Not that they have given it a matter of charity. It's not a lease land. It's land which they have given to me.
Mr. Mishra, what we can do is this.
Yes, my lord.
We'll ask them to examine the whole issue in light of the report of the Amin
Correct.
and the report of the Advocate Commissioner.
Right.
Second, if they're able to remove the obstructions and deliver possession of land free of all obstructions, then that can be done in a time-bound manner.
Yes, my lord.
If they're unable to do it within that time, they should explore the possibility of giving alternate land.
Well, highly obliged, my lord. Highly obliged. That is the most fair order my lordship will pass, my lord.
All right. You say
That is what I am submitting.
Mr. Dayananda Mahapatra has been paid his fees or not yet?
They have been paid their fees.
There are two commissioners, Dayananda Mahapatra and Siddhartha Mishra.
They have been paid fees.
You can take your fees. It is deposited.
All right. You say on 25th October 2017, following order was passed in the present two petitions. Subsequently, reports have been submitted. Both by the Advocate Commissioners, Mr. Dayananda Mahapatra and Mr. Siddharth Mishra, as well as the Amins. Paragraph. This court has heard the submissions of Mr. Manoj Mishra, learned counsel for the petitioner, Mr. D.K. Mantri, learned additional government advocate, and Mr.
Rahul Mantri on behalf of Mr. D.P. Mantri.
Mr. Rahul Mantri on behalf of Mr. D.P. Mantri. Mr. Mishra submitted that both the reports indicate that there are obstructions in the form of electrical substations, oblique transformers.
And private encroachers also.
And there are some private encroachers also. His submission is that if the plots are unable to be delivered to the petitioners free of all encumbrances, encroachments, and obstructions, then the General Administration Department, bracket GA department, should consider allotting alternative plots to both sets of petitioners.
No, no, petition number one. Petition
Only
number-
one, petition number one. Only.
What about
Under-
that adjoining petition?
No, petition number two is the procedure.
No. There is a connected matter, sir, 2006
No,
matter.
connected
He-
matters,
he-
they
that
are for
voucher.
private
The
land.
connected matters, we
They
are
are for private land, private
as a
owner.
private land that 1266 and 1265.
She
We are
is
claiming
found to
as
be the encroacher. And she
as
has.
per the report, they are saying we have encroached certain portions of land.
No. Appearing for the petitioner, the accompanying matter
Then
No,
Mr. DP Mohan.
I am appearing. my lord.
for the petitioner.
Yes, my lord.
What is your prayer?
As per the report, it can be directed. As per the report, they are claiming that they will be giving us a proposed 20 feet land. After
Alright.
removing all the encroachment, we have no issues in that.
All right.
As per the report, it can be disposed of.
All right. You say alternate plot as far as petition number 1 is concerned. In the accompanying petition, council will.
Petition one and two, because two is also purchased to petition number one and two.
All right, petitions 1 and 2. In the accompanying petition 5802 of 2006, council the petitioner states that if the report of the commissioners is implemented, their grievance would be met. In view of the above submissions, the following directions are issued. 1. The GE department will examine the reports of both the Amines as well as the advocate commissioners and explore the possibility of handing over possession of the plot of land as far as petitions 1 and 2 in petition 33436 of 2011 is concerned, free of such obstructions within a period of 4 months.
My lord may make it 6 months because there is a lot of formalities have to be complied.
All right, within a period of 6 months from today. And not later than 4th April 2023. 2, if the plots are unable to be delivered in the above manner within the date indicated, the GA department will provide alternative plots of the same size to petitioners 1 and 2 in petition civil 33436 of 2011 within a period of 4 months thereafter. 3, as far as writ petition civil 5802 of 2006 is concerned, acting on the reports of the Amin and the advocate commissioners, the steps will be taken to provide the pathways for access to the plots in question as suggested in those reports. This again be done on or before 3rd April 2023. Paragraph, it will be open to the parties if there is any difficulty in carrying out the above directions to apply to the court for further directions. Full stop.
And your lordship may order that it is open for the GA department to take in action against the encroachers.
Obviously, sir, that is for you to take action. The petitions are disposed of in the above terms. All right.
Deeply obliged. Deeply obliged.
You say the fees of the advocate commissioners be now disbursed to them by the registry forthwith. Right.
Deeply obliged.
Right.
Supplemental list, old matter, item number 4.
Wait, please, Your Lordship. My Lord, on the last occasion on 29th of June, my Lord, I filed my rejoinder. Today, I have received a copy of an additional counter. My Lord, I'm conscious it's an old matter. My Lordship grants me 2 days time to obstructions on this new document which has been given to me today. My Lord. Lordship can have it
They
day after
stated that
tomorrow.
there is an additional counter filed today by opposite parties 1 and 2. Mr. Das, counsel appearing for the petitioners, needs time for instructions thereon. List on 23rd November,
Obliged, my Lord. Interim orders may continue.
interim order to continue.
Obliged.
Item number 5.
My lord, item number 5, my lord. May I please your lordships, my lord. My lord, may I see the last 2 orders passed by your lordships, my lord. order dated 21st of March 2022 and order dated 29/6/2022, my lord.
The affidavit has not been filed.
Yes, my lord, I'll take some time. Post vacate.
Last opportunity to the opposite party state to file their affidavit on or before 14 November 2022. List on 7 December.
Item number 6.
This matter, for the timing, there is no instruction.
All right.
If any cause of action arises in future, the petitioner may permitted to.
All right. Counsel for the petitioner seeks leave to withdraw the present petition with liberty to file a fresh petition if any cause of action arises in the future. Disposed of is withdrawn, liberty is paid for. All right.
Supplementary list item number 7.
May be permitted to place the matter on behalf of Mr. Mahanti, my lord. The petitioner, while continuing as after being selected, while continuing as Anganwadi worker, my lord, he was disengaged.
Continuing as?
Anganwadi worker, my lord.
Ah,
He was disengaged from the service. That disengagement order was SL before this honorable court, and the honorable court, without appreciating the material facts on record, has upheld the same. And now before this petition is reported in the writ appeal, my lord. Until date, the state, being the contesting respondent, has not yet bring its counter to the record, my lord. Because of the fact that as per the voter list, the petitioner belongs to the service area. And after due inquiry, he was selected and was while discharging his duties as an Anganwadi worker, disengaged, my lord. The legal question here is, my lord, while there is an advertisement by the competent authority inviting objections to the applications, and in absence of any objection to that effect, whether a private opposite party number 4 can file an appeal before competent authority to assail the same, my lord. When opportunity was given by the state authorities to file in objection, in absence of any objection to that effect, when the process of selection was continuing and it attained finality, the petitioner was selected and appointed, and while discharging his duties, the disengagement order came into force.
no, but come to page 12, sir.
Appellant. You are appellant.
Come to page 12. Please read the last paragraph. Petitioner being a
Petitioner
candidate.
being a candidate, although has been selected, but on the ground of having not resident of the area where the center is situated, it is factually incorrect.
Please read the whole paragraph and then make your submission.
I'm sorry.
Sir, when you argue an appeal, first you have to tell the court what is wrong with the order under challenge in the appeal.
My lord.
That is not how you people argue. This is the whole problem.
Petitioner being a candidate, although has been selected, but on the ground of having not resident of the area where the center is situated, the same has been complained by the private opposite party before the sub-collector by preferring appeal, in which the appellate authority has given ample opportunity to the petitioner to produce documents, but no residential certificate showing any proof of local area where the center is situated has been produced by the petitioner. Rather, the petitioner opposite party,
Private opposite party.
rather the private opposite party has filed survey report, which the private opposite party has obtained under
Which
the
the
provisions of-
prepared by the petitioner. What are you reading, sir? Right, which the private opposite party has
has
obtained.
obtained under of the Right to Information Act, which was prepared by the petitioner and countersigned by the CDPO, in which it has been specifically mentioned that the petitioner has not been enlisted in the said list. Rather, in the survey report, house of the private opposite party is situated at serial number 100. Based on the survey report, the appellate authority came to conclusion that the petitioner is not resident in the local area where the center is situated, my lord.
What is your argument, sir?
Clear observation.
What is your argument?
Your lords, may kindly turn to para number 6, my lord, at page number 4. That after the appointment of the appellant, the respondent number 4 have never objected, though there was a provision of objection. On
What
the
is
other,
factually, sir? What is all this? Factually, are you a resident or you're not a resident?
I am a resident, my lord.
What do you have to show that?
Your lordship,
Where is the document to show that?
para 11, my lord, para 11.
Appeal means
The record of right. That the appellant is the permanent
Sir, did
resident
you
of.
produce it before the authority? That's the question. Are you now producing it for the first time in the High Court? In the appeal, and the appeal, did you produce it before the sub-collector?
Your Lordship, may grant me liberty that
No. Nothing like this. This is not some luxury litigation here going on.
the record of
You
right
have to
was
be serious about this litigation, sir.
My Lord, the record of right was produced, my Lord.
No.
That was
Where is the proof to show it was produced?
Your Lordship, may kindly see the record of right is annexed 2 series.
You are annexing it here. Please
Yes.
try and follow the question that is being asked. There's a clear finding by the single judge that you did not produce any material.
But the fact remains that the documentary proof that the document is of the state authorities, my Lord. It cannot be discarded merely because
The challenge in the present appeal is to an order dated 8th April 2015 passed by the learned single judge dismissing the appellant's writ petition civil 16430 of 2010. Paragraph. The background facts are that the appellant was engaged as an Anganwadi worker, bracket AWW, at the Nuwa Sahi Tentulia Anganwadi Center -2 bracket AWC. Full stop. Respondent before, who also was considered for the said post, challenged the selection of the appellant on the ground that the appellant was not a resident in the area. Full stop. The sub-collector, being the appellate authority, relied on the survey report that was asked for and found that, in fact, the appellant was not a local resident. Full stop. Respondent before, on the other hand, was found to be a resident of the area. Full stop. Paragraph. The learned single judge has, in the impugned order, specifically noted ample opportunity was granted to the appellant to produce documents, open quotation, but no residential certificate showing any proof of local area where the center is situated had been produced by the petitioner. Full stop, unquote. On the other hand, respondent before obtained information under the Right to Information Act, which was countersigned by CDPO, specifically stating that the appellant was not included in the list of houses, showing that the appellant was not a resident in the area where the center is, where the AWC was located. Paragraph. Before this court, copy of the record of rights is sought to be annexed as Annexure 3 series. No, sorry. Annexure 3. Annexure 2 as Annexure 2. No. Where is that ROR? Para 11 you said.
it starts from page
Annexure
number
3 series. Yes.
17.
Oh, Annexure 3 series, which full stop. Nowhere is it indicated that these documents were placed before the sub-collector. Full stop. The view of the specific finding of the learned single judge that the document was unable to be produced by the appellant. It was incumbent on the appellant to indicate clearly that despite producing such document, the sub-collector did not consider it. Full stop. In the absence of such a pleading, the only inference that this court can possibly draw is that these documents are being produced for the first time at the appellate stage in this court. Full stop. Clearly, the appellant cannot be permitted to do so at this stage. Paragraph. The court is unable to find any error having been committed by the learned single judge in rejecting the writ petition of the appellant. There is no merit in the present appeal and it is dismissed as such. The interim order stands vacated.
I'm grateful, Your Lordship.
Item number 8.
Non-appeal is dismissed.
Appeal for the opposite party.
Item number 9,
Infructuous, ma'am.
Infructuous dismissed.
item number 10,
Non-appeal is dismissed.
supplementary list item 11,
The Lordship may take up writ appeal 253 of 2015.
Yes.
It has got a complete set, in fact. But here the short question is, the
Yes.
writ has been held to be not maintainable on the ground that the vendor of the present petitioners, they had filed writ application, which was subsequent to the writ application filed by the petitioner. 2004, the petitioners filed challenge the order of the commissioner. 2005, the vendor filed. Vendor withdrew. The Honorable Court held, once the vendor has withdrawn, that your writ becomes infructuous and you don't have a right.
How can
But
that be?
That is the question of law.
No. I have a small data.
If I just show you also the finding of the Honorable Single Judge. One second. Kindly turn to the order passed with Honorable Single Judgment.
Annexure 5.
Page 64.
Page 84.
Yeah, 86 it starts.
Paragraph 6, Madam.
Yes.
Page 91, for the aforesaid discussion, the present writ application at the behest of these petitioners who are strangers to the consolidation proceeding are not mentioned. They cannot pursue this writ application, firstly, because not parties to the consolidation proceeding, and secondly, having not approached the authority under the Act at any point of time, when also the basis has come into existence as ascertained only during the lease and is not seen to be giving rise to a claim of title. As already stated, the entire claim of this petition is founded upon the so-called agreement executed by the pro forma opposite party number 5 in their favor. Thus, on their own swing, they have no title over the land in question. Here in course of argument, it is simply contended on behalf of the petitioner that opposite party number 5 has by now registered sale deed in favor of the petitioners. However, neither any averment to that effect remains by way of affidavit, nor any document has been filed. Accepting this for a moment, now therefore the matter becomes further clear. Those allegations of suppression of material fact or documents, whatever the case may be, as levied by this petitioner.
So once this is a registered sale deed, how can you ignore the right to the
Yes, Your
petitioner?
Lordship. Now the entire genealogy is Your
You
Lordship.
washed off your hands, you conveniently executed the
I am
sale
not the
deed.
vendor, Your Lordship. I am not the vendor. To be very
Who are
honest,
you?
So they are disputing in regard to the title. They claim to have purchased. OP number 5 claim to have purchased.
That will be examined.
Yes, that is exactly.
The Your Lordship is. I'll refer to my date chart.
Sir, interestingly, one point I would like to bring your Lordship notice.
So the same land has been sold to several persons.
Yes, sir, consolidation proceeding went in their favor, 2-4. Appeal was filed. Appeal was allowed, saying that there is procedural irregularity antedating the order. It set aside the order and remanded the matter back to the consolidation officer. That was challenge and revision. But revisional court set aside the appellate court order, but did not say the appeal to proceed. He said you take steps in appeal. But consolidation lordship knows once that area is over, a court directs for functioning, it will not function. So the appeal is still in a
limbo.
Yes, ma'am.
Whatever.
Now I filed a writ application 2004, earlier to the opposite number 5. My writ was allowed because possession was in my favor. And therefore the court entertained the writ
These are not
application.
disputed question of facts.
Interim order was passed.
They could have gone on a civil suit for declaration of material interest, my Lordship. The entire case is they're relying upon a sale deed executed by OP number 5 who didn't have a valid title itself.
Who is your vendor?
My Lordship, my father has purchased a land in the year 1974.
From whom?
My Lordship, that is stated. My Lordship, kindly see the impugned order.
And
para 2A. The one Damodar Singh, 2A, my Lordship, page number 86. The one Damodar Singh, the father of the OP number 224 of WPC number so-and-so, namely Tilochan Singh, Durga Prasad Singh and Ashok Kumar Singh, had purchased a disputed property from the original recorded owner by registered sale deed dated 48, my Lordship, in the 1948.
And there was a partition in the family by a document, registered document.
I'm not disputing my
After it
lordship.
fell to the share of the
If
person.
my lordship,
So there are so many purchases of the same property under different sale deeds.
Four properties, your lordship. There are 4 properties.
I know, but therefore different registered sale deeds.
Yes, your lordship. If the only
And
claim
in
is
respect of some of those properties, there are rival claimants.
Right.
now this OP number 5, so the vendor of the appellants, now he's come forward and saying that there is a valid sale deed, but my lordship, that has been considered by the consultation officer, your lordship. Once they're
No, but it has happened.
And moreover, my lordship, in the title suit, I have also
one minute. At the time they filed the writ petitions, they did not have registered sale deeds. There is a subsequent development.
Yes, your lordship.
So that has to be taken into account.
Care of my lordship in the single judge.
No, it has not. He simply says that there's no averment in that regard.
Yes, your lordship. It's subsequent development.
Once there is a registered sale deed,
by whom, your lordship? Not by the OP number 2 to 4. By OP number 5, who didn't have a valid registered sale deed.
So that has somebody has to examine all that, correct?
My submission is,
I think submission is that it can't be non-suited at the threshold.
It is a disputed question of facts, your lordship. Let them appeal to civil court for declaration of lateral interest. Who is denying them?
No, in consolidation proceedings, there must be an exclusion of civil court.
Remanded matter.
My lordship, the competent court is the civil court, my lordship. If they found that it's a valid registered sale deed, they can always claim that, your lordship.
No, who's going to? He's got a registered sale deed. Why would he go to court?
By a person.
Anybody who's questioning that registered sale deed will have to go to the civil court.
Yes, your lordship.
As long as he's got a valid sale deed in his favor, he's not going to go to any court.
A person who didn't have a valid title and interest over the property.
No, that since you're challenging his title, you will have to go to the civil court then.
I'm not challenging your lordship, but the land is recorded in my favor.
You're saying his vendor has no valid title to convey, so the registered sale deed is not valid. That's your plea.
That is the concrete finding, your lordship.
No. Question is that should he be heard or not at all to challenge that?
The civil court may have a declaration of lateral interest.
No. One is to send it back to the single judge.
Yes.
That's the only way to do it.
Then my submission is, my lordship, the notice has not been issued in this matter. Open respond now 5 also be appeal in this matter, your lordship. For the first time, the appeal is coming.
These appeals have never been heard before. Sir? These appeals have never been heard before.
This matter?
Yes.
Not heard before.
My goodness. For the first time in 7 years.
No, but they have appeared. There's a contesting party. They have already appeared.
That's right. They've all appeared.
2 to 4 only, my
lordship. The first time it is listed.
They are the contesting party, my lord.
The 5 is their vendor. They themselves are saying that they have got the title by way of OP number 5.
He's not interested. His OP number 5 is not going to be interested. You're the one who's affected. The affected parties before us. OP number 5 has washed his hands off long ago. He filed a writ petition which he withdrew. That's the finding. So he's not going to come here to contest this at all.
In the year 2010, my lordship, when they have executed
that OP number 5 is not be interested in contesting this petition at all.
My lord, so far as these lease pendants registered sale deeds are concerned, those are not taken care of by this honorable single judge. What your lordship can
find. He has not decided on merit.
He has, so that can be
remanded to the single judge. Is a short ground on which the present writ appeals have been filed, challenging the common order. Is it a common order?
Common order.
Common order dated 10th April 2015 passed by the learned single judge is that the present appellants have been non-suited at the out by the learned single judge on the ground that the later writ petitions filed for the same relief by the vendors of the petitioners, vendors of the present appellants, were dismissed as withdrawn by the learned single judge. Full stop. Paragraph. The grievance is that these appellants had filed writ petitions which were earlier to the ones filed by their vendors. Full stop. The second development was that during the pendency of the writ petitions, the vendors executed registered sale deeds in their favor. Full stop. The learned single judge has, despite noticing the above development, observed that since there was no averment to the effect by way of an affidavit, nor any document filed, the present appellants have to sail in the same boat as vendors. and therefore their writ petitions cannot be entertained. Paragraph must be mentioned here that in the present writ appeals, the main contesting parties are respondents 2 to 4, represented by Mr. Biswal, an advocate, who questions the validity of the registered sale deeds in favor of the present appellants on the ground that respondent 5, their vendor, himself did not have any valid title to convey. The second contention is that the validity of the RSDs can be tested only in separate civil proceedings and not in proceedings under the Orissa, that long fragmentation of holding, consolidation and fragmentation of holdings Act, bracket Act, paragraph. The fact of the matter is that the present appellants did not, the writ petitions filed by the present appellants did not receive consideration at the hands of the learned single judge, only on the ground that the later writ petitions of their vendor were withdrawn, full stop. Considering that the petitioners are claiming right, title and interest in the property in question through registered sale deed, it was incumbent on the learned single judge to examine the writ petition on merits, the writ petitions on merits. Full stop. It is clarified that this court has not expressed any view thereon, as it is important for the learned single judge to first examine the writ petitions on merits. Full stop. Therefore, leaving open all the contentions of both the present appellants, that is the writ petitioners, as well as the contesting respondents 2 to 4, bracket, who are the contesting opposite parties in the writ petitions, bracket, open for consideration by the learned single judge. This court sets aside the impugned order dated 10th April 2015 in the writ petition numbers, put all the cost titles together, and restores the above writ petitions to the file of the learned single judge in the roster bench, where it will be listed for hearing on 7th December 2022.
Grateful.
The learned single judge is requested to proceed with the hearing of the writ petitions and dispose of them off as expeditiously as possible. You said till the disposal of the writ petition, status quo shall be maintained by the parties. All right.
Item number 12.
None appears dismissed.
Item number 13.
May I please, Your Lordship?
Yes.
The only question to be adjudicated, Your Lordship, whether a person filed documents, residential certificate after the after date, eligible for selection and appointment.
Anganwadi worker.
My kindly see the impugned judgment, page 45 of the Honorable Single Judge. At page 45, and Annex 11, mine.
You challenged her appointment and you lost.
My lord.
So she has filed a residential certificate after the cutoff date.
Cutoff date.
So there cannot be extension of time for producing that certificate. What is the, let's see the impugned order.
Page 45, my lord, para 2. There is the impugned order. I find that OP6 has produced the said residency certificate before appellate authorities. Therefore, she could not produce the original certificate at the time of verification, which was subsequently done.
This is a contrary to what you've been saying.
Please. My lords, in fact, I should place it fairly that last week my lords had passed judgment.
That you can't extend the time.
Yes, my lords. Writ appeal 122 of 2015.
Now, this is coming up the first time.
My lord.
Meanwhile, that woman is working now. How many years she's been working, sir? You leave her alone now. This is what happens in these matters. If you don't get them listed immediately.
Because of your lordship matter.
I know. Otherwise, it would not come up at all. Considering that respondent number 8, whose appointment as Anganwadi worker was challenged with the present appellant, has been continuing as such since 2014.
My lord.
That is, for more than 8 years, the court leaves the question of law arising from the impugned order open for decision in some other appropriate case. The writ appeal is accordingly disposed of. Right.
Item number 14.
Delay.
In this case, my lord, the respondent was the driver and the appellant. He caused the accident causing death of the child. Madam.
So 267 days delay.
Yes,
You have to first address that, sir. MC 357 of 2015, there's a delay of 267 days in filing the present appeal. There's no satisfactory explanation of the delay. Consequently, the court is not inclined to condone the delay. The MC is dismissed. Consequently, the writ appeal is dismissed. All right.
Item 15.
Requisites for limitation have not been filed.
It was filed, your lordship.
Filed late.
2-3 days or 5 days, my lord, delayed.
No. 11th March 2016 you filed, sir. This is a 2015 writ appeal.
No, the notices were issued, my lord, on 25/2 possibly. 16.
No. You filed the writ appeal itself in 2015, sir.
Your lordship, may I kindly look at order dated 23/2/2016.
Right.
That was the notices were issued. I was supposed to take steps within 3 days. Instead,
even then you didn't take steps.
After 10 days.
Almost 10 days.
10 days, my lord.
No. You say requisites. No, steps for limitation.
Even after superannuation, my lord, my gratuity has not been released, though the service rules do not provide for retention of the same. That was the subject matter before the Honorable Single Judge.
Now, what does the Single Judge say?
He says because a disciplinary proceeding is pending, this will be I have to meet that. I have to go and appear there.
Correct.
The question is that doesn't their service rule doesn't provide for continuation of a proceeding after, my lord, my superannuation, and that has been covered by this Honorable Odisha High Court's judgment, my lord.
What has happened in the disciplinary proceedings? By now it should be over.
It has not proceeded further. After superannuation, in any case, they are aware, my lord, in view of the judgment in 99 relating to Orissa State Financial Corporation, a similar matter, my lords. It could not have Bhagirathi Jana case because the service rules do not provide for continuation of proceeding because it is not a pensionable establishment. And the Jharkhand decision also, your lordship is aware, where this got reported in 2014 one OLR, where my...
What was the delay in filing the writ appeal?
Writ appeal was, your lordship, 19 days.
All right. The delay is condoned. 374 of 2015 is allowed. Then the main writ appeal. What do you say, sir? Who's for what's the OSRTC, is it?
No, Agro Industries.
All right. Main writ appeal, you say notice returnable. 30th November. Yes.
Item 16.
Delay. Why are you chasing a judge, sir?
And otherwise also it has become infructuous because he is already.
All right. Counsel for the appellant stated the appeal has been rendered infructuous. Disposed of the section. Right.
Item 17.
17, my lord. Senior advocate Mr. Roth is appearing. I prefer some other terminology. He is not well, my lord.
What is there in the matter, sir?
But the file with Mr. Roth, my lord, he is not well for that reason.
Let us see what the matter is about. Two letters are at flag C and D. Let's see that. LIC. So they want to file a closure report because of this pendency of the present appeal. They're not able to file the closure report. You see, letters have repeatedly been written by the Superintendent of Police and HOB CBI Bhubaneswar to this, seeking leave of this court to file the final report, bracket closure report, in the court of the London Special Judge CBI, Court number 1, Bhubaneswar, in CBI Bhubaneswar branch case number RC 015201 5 capital A 0010 full stop. It is seen that the direction issued by the London single judge for the CBI to carry out investigation has been already complied with in the above manner. Full stop. Consequently, no further directions requires to be issued by this court in appeal, since what is sought to be filed is a closure report. Full stop. The said direction worked itself out. Paragraph, permitting now the CBI to proceed in the matter to file the closure report as proposed, and for the court concerned to thereafter deal with it in accordance with law. The writ appeal is disposed of.
Let's see, my call it on Friday, my lord, because Mr. Roth is not well.
It's all right, sir.
Because there are 2 parts, my lord.
This has already got severely delayed, sir. This got seriously delayed.
Let's call it after launch, my lord.
No, 1 minute. The second matter is also same thing.
The second matter, the dispose of case which arising out of the writ application file, my lord.
No, writ appeal. The second is also writ appeal.
No, my lord. The writ application filed challenging the order.
Disposed of case. Right. That's fine, sir. No further order, sir.
Item 18.
Let's call it after launch, my lord.
It is not necessary, sir. The LIC's interests have been taken care of. No order adverse to LIC has been passed. All right.
No, my lord. I'll satisfy after launch, my lord. Let's call it after launch.
There is no order adverse to LIC, sir.
No, the direction to payment of LIC, my lord.
Closure. No. That closure report has been filed.
That is direct to the CBI, my lord.
Right.
LIC is direct to pay the compensation, my lord.
Correct.
That order we have challenged, my lord. Yeah, let's call it after launch. I'll satisfy, my lord.
All right. Call after lunch.
Your lordship, appearing on behalf of CBI.
Yes.
Your lordship, my presence may be recorded.
But we are calling it after lunch, sir. 2 o'clock. Yes.
Item number 18.
Infructuous, your lordship. Infructuous dismissed.
Item number 19.
I'm for the opposite, but
None appeal is dismissed. In the 18, the contempt petition is disposed of.
In 19, I am for the Kendra Vidya, opposite.
All right, sir. None appears dismissed.
Item number 20.
None appears dismissed.
Item number 21.
Item number 20. The counsel for the petitioner has expired, and also I don't have power and instruction in this case.
Yeah, counsel with the appellant states she has no power or instructions. Appeal is dismissed for non-prosecution.
Item 22.
Item 22, Mr. Mishra has requested me to say that there is no instruction in the matter.
No instructions dismissed. All right.
Item 23.
None appears dismissed.
Item number 24.
None appears dismissed.
Item number 25.
Highlight been misplaced. Counsel says the File is placed, dismissed with liberty to revive the appeal in case the file has been traced.
Yes.
Item number 26.
Item number 26, your lordship has passed order, last order, 29th September 2021. Mr. M.S. Saul, London Additional Commander for the appellant, state that he will produce on the next date the original record of right as it as present. But
Not available.
not,
Despite the order dated.
no, there is no record to show that he has called for, but I may be permitted to get that record of right. Your lordship wanted to know what is the extent of land involved in this case, because the Tahsildar has so much exercised this power under Rule 34 and allowed the quota to be corrected. Other side challenge that it is post publication of final record of right. So Rule 34, Tahsildar has no jurisdiction. My claim was that Tahsildar had the jurisdiction because of some anomaly. The Tahsildar initiated the so motu proceeding. Now your lordship wanted to know what is the extent of land, because it is not the extent of land, but the principle has been decided by the learned honorable single judge in the
All right, at the request of learned additional government advocate, who needs time to produce the original record.
In terms of the order dated 29th.
Yeah, in terms of the order dated 29th September 2021, list on 20th December, 20 December.
Item number 27.
27, no instruction.
No instructions dismissed.
Item number 28.
None appeals dismissed.
Item number 29.
In item 29, my lordship, during the pendency of the appeal, the sole appointment has expired. Lordship, with the liberty, if the legal ayahs appear, my lordship, they can pursue the appropriate remedy.
All right. Counsel for the appellant informs the court that the sole appellant has expired. Paragraph. Granted liberty to the legal representatives of the appellant to pursue appropriate remedies in accordance with law. The appeal is disposed of.
Name of Mr. Mahapatra will record respondent number 2 and 3.
Item number 30.
Item number 30, notice return to legal heirs of opposite partner 5. If 5C return answer, I may take permitted to take fresh notice.
What is the matter about, sir?
Matter, the writ petition not maintainable. I have the opposite party. The petitioner is working as.
You are the opposite party.
In the writ petition. The petitioner was working as a clerk in an aided education institution. He was promoted to post, he would declare head clerk. Therefore, he filed a GI case before the Honorable Tribunal, Education Tribunal, for approval of appointment and release of granted. Under Annexure 1 of the order of the tribunal, the London Tribunal directed the opposite party 1 and 2 director and higher and state government to inquire into the matter and pass appropriate order. The opposite party number 5, who is a writ petitioner, he also appeared with director and government, and thereafter the government approved the appointment of the petitioner and pass order for release of granted. Only thereafter, the opposite party number 5 filed the writ petition seeking that the London Tribunal has no duty to pass order for inquiry and pass order. She has to pass the final order. So my ground of challenge is that when he participated in the inquiry, he waived his right and he is precluded from challenging the same in the writ petition.
There is no stay of the impugned order. Is there a stay? Is there a stay order in this appeal staying the impugned order of the single judge? Question. Are you able to hear me, sir?
Yes, Miller.
There is an order of the single judge, correct?
Yes.
Has that order been stayed by this court in this writ appeal?
No, that is not stayed.
So what is the consequence, sir?
The consequence if the writ appeal will be allowed. Then,
sir, what is the consequence of not staying the impugned order of the single judge?
Then the London trial court.
Trial court? You're not even reading the impugned order, sir. Where does trial court come in?
The impugned order, they remitted, the honorable single judge remitted back the matter to again to the tribunal.
Where is the trial court coming here? What are you telling trial court? So it is remitted to the tribunal.
Yes, Miller.
That order has not been stayed.
Not stayed.
Which means what would have happened?
no notice has been also issued from the tribunal for appearance.
Everybody has gone to sleep, basically, according to you. You went to sleep, you filed this appeal, you went to sleep. No stay, nothing.
But if the
single judge sent it back to the tribunal, tribunal went to sleep.
But
if we had not listed it today, all of you would continue sleeping.
But in the event this order is passed, the order of
you did not even participate, sir. Notice was made complete on you before the single judge. You did not even participate.
But I have filed counter, but in presence of my lawyer, counsel, the honorable.
It's all right. The impugned order of the learned single judge merely remits the matter to the tribunal for a fresh decision. Having heard learned counsel of the appellant, the court sees no reason to interfere with the impugned order of the learned single judge. It may be added here that during the pendency of the present appeal, there was no stay for the last 7 years. There has been no stay of the impugned order of the learned single judge. Full stop. For all the aforementioned reasons, the court finds no merit in the present appeal. It is dismissed as such. All right.
Item number 31.
Liberty to pursue the matter there, Miller.
Yes.
Miller, I may be granted liberty to pursue the matter there.
31.
None appears dismissed.
Item number 32.
Please, my lord. This application, as far as the appellants are concerned, they were not parties before the learned honorable single judge, my lord. So they have filed an
limitations not taken, sir. Steps for limitation also not taken for the last 7 years. For the last 7 years, steps for limitation have not been taken. Full stop. Clearly, the appellant is not interested in pursuing the matter. It's dismissed as such. Yes.
Item number 33.
Please, your lordship, my lord. There it has been shown that limitation step has not been taken, but that the appeal is not barred by limitation. The period of granting certified copy has not been taken into account. Lordship, kindly see.
What is the matter about?
Matter is regarding the approval of service of the petitioner as night watcher comes report, that is third year in the ended high school, my lord. The learned single judge did not give me opportunity to file the reply to the counter affidavit of the contesting opposite partner for my lord, respondent of court, my lord. That is my first submission, my lord. That no opportunity was given. Then the respondent number 4 was appointed against the terminated vacancy, my lord. Earlier to me, I was appointed specifically against the post of night watcher of sweeper at third. But the learned single judge, the honorable single judge held that as he is senior and earlier appointed, his service shall be approved on the basis of a Himachal Ponda case, which is not applicable to the present case at all. This is the point, my lord, before. The lordship kindly, I am taking to your lordship kindly see the counter affidavit has been filed by the respondent number 4 at page 40, my lord. Annexure 10. I received on 31/7/2015 at the time of hearing.
Mr. Mohanty.
Yes, my lord.
Your client has superannuated quite some years ago, correct?
My lord, in that
respect, yes. He was 59. He was 59 when he filed his appeal in 2015.
Yes.
Or we leave the questions open, sir. Considering that the appellant has superannuated long, leaving the questions of law open, arising from the impugned judgment of the learned single judge open for consideration in some other appropriate case, the writ appeal is disposed of. Right.
Item number 34.
None appears dismissed.
Item number 35.
35. State is the appellant against the engagement of an Anganwadi worker.
Leaving the questions of law arising from
and we have already
delays what
120 days.
120 days not properly explained.
My lord, we have already implemented the impugned order, giving an affidavit that's subject to result of the writ appeal.
All right. It's further seen that the delay is not properly explained. Further, it is informed that the impugned order has been implemented subject to the outcome of the appeal. The court is not inclined for the aforementioned reasons to
and accordingly, affidavit was filed on 13th March 2018.
All right. Accordingly, the writ appeal is dismissed. Right.
Well, my submission is that they have
dismissed the writ appeal, sir.
I'm for the respondent, my lord.
We have dismissed the writ appeal.
Right.
Item number 36.
None appears dismissed.
Item number 37.
Permitted to withdraw.
Counsel of the appellant seeks leave to withdraw the present appeal. Dismisses withdrawal.
Item number 38.
None appears dismissed.
Item number 39.
None appears dismissed.
Item number 40.
In item 40, I am not able to get instruction.
All right, no instructions.
And with the Lordship's kind permission, connected acting at writ appeal 595 of 2015 may kindly be taken on board and disposed of.
All right.
Writ appeal number 595.
We mentioned that 595 to 2015. This appeal is dismissed in view of the order passed today in 596 of 2015. All right.
Item 41.
It may please your lordships. My lord, I have challenged the judgment of the Honorable Single Judge, that is 8/10/2015 at Annex 8, on the ground that during the adjudication of the writ petition, the Honorable Single Judge directed the crime branch to make an investigation whether I have filed an affidavit before the offending authority at the time of making application that I am a permanent resident of that village. And the crime branch gave a negative report for which that my writ petition was dismissed. On the ground, I am continuing in service for last 11 years, my lord. And crime branch report is a police report, my lord. And that cannot be, my lord, taken into consideration in service matter that I have not filed, my lord.
No, that's a state authority, sir. We have wait. The
I am not given an opportunity in that inquiry, my lord. I am coming to that. The advertisement was made, my lord. But the advertisement was made on 23/11/2009, my lord.
So now you've continued for 11 years. There's a stay here also.
Yes, I haven't continued my service.
Has the other party been served?
No, other party was disqualified, my lord. He was not taken into consideration, down of consideration for
She has continued now for 11 years, sir.
Yes, I am continuing for 11 years.
So let it be then. Let that status quo continue. You say the challenge of the present appeal is to an order dated 8 October 2015 passed by the learned single judge. Dismissing the appellant's writ petition civil 8613 of 2013, whereby her challenge to the order passed by the additional district magistrate, Kendrapada, cancelling her engagement as Anganwadi worker at the Basantpur Additional Anganwadi Center was dismissed, was rejected. Full stop. As far as the present appellant is concerned,
She has been continuing since 9/5/2011.
as far as the present appellant Sanju Lata Rao is concerned, the single judge mentioned Sanjukta Raut.
That is Sanju Lokta, my lord.
Wrongly mentioned as Sanjukta. It was challenged by respondent before Srimati B. Jaina on the ground that she had not submitted any affidavit in support of her permanent residence. Full stop. An order was passed by the single judge on 18 June 2015 requiring the crime branch to investigate into the matter and submit a report. Full stop. Pursuant to the above order, the crime branch submitted a report from which it was noticed as far as the present petitioner is concerned, present appellant is concerned,
Submitted the affidavit under annexure to later on, my lord. That is there. I submitted the affidavit.
She had not submitted an affidavit regarding proof of her residence. And yet the selection committee had approved her appointment, had recommended her appointment. Full stop. The fact of the matter is that during the pendency of the petition before the learned single judge, there was a stay of the disengagement of the present appellant. Stop. Even when the present appeal was pending in this court, by virtue of an order dated 11th April 2016, there was a stay of the order dated 4th April 2013 of the ADM Kendrapada. Stop. In other words, ever since her engagement on 9th May 2011 till date, that is for over 11 years now, the appellant has continued as such. Full stop. The short ground on which the challenge is laid to the impugned order of the learned single judge is that the report of the crime branch was not furnished to the report of the crime branch was prepared without any notice to the present appellant. And there's no occasion for the appellant to produce materials before the crime branch in support of a plea that she was a permanent inhabitant of village Basantpur, and also produce the residential certificate issued by the Taj Nagar. Full stop. Indeed, it does appear from the order of the learned single judge that there was no notice to the present appellant when the report of the crime branch was prepared. Full stop. There should have been an opportunity granted to the appellant to contest the report of the crime branch, as it was going to adversely affect her engagement as AWW. Full stop. On that ground, the court sets aside the impugned order of the learned single judge and allows the writ appeal. No orders is to cause.
The order.
The order of the ADM is also, corresponding order of the ADM is also hereby set aside. Right.
Item number 42.
The appellant hearing challenge is order passed by the Honorable Single Judge of the National Court, wherein the writ application filed by the appellant has been dismissed, and you'll also kindly turn to page 10. On the reasoning, admittedly, the present respondent has not filed any counter affidavit to the writ application, and on the date of hearing, the respondent submitted before the Honorable Single Judge that a counter affidavit filed in another writ application is OJC number 4873 of 1996. They adopt the counter in the writ application on the date of hearing of the writ application, and the Honorable Single Judge, and no copy of the counter affidavit has been served to the present appellant, who was the petitioner before the Honorable Single Judge, and the findings, the concluding part of the Honorable Single Judge.
Now you can't expect to deposit some 29,000 and get a shop. The shop must be worth lakhs of rupees.
He is in possession of that shop.
He's already in possession.
He is in possession. My lord, two categories of shop rooms are advertised.
Yes.
One is on outright basis, another is on installment basis.
Are you prepared to pay the market value, today's market value of the shop? Are you prepared to pay?
Well, final allotment has been made.
Are you prepared to pay the money, sir? You delayed in making some 30,000 payment. Are you prepared to pay the market value today?
Yes, madam.
You're prepared to pay the market value?
Present
Market value means what, sir? What is present market value?
We are around minors more than 6 crores.
That's
6 lakhs,
what.
6 lakhs.
Someone, two category of plot has been.
And you just got a status.
Two category of plot has been.
Almost every allotees minors, 5 of them come before the Honorable High Court. They lost
status quo.
On the same case, they lost. And referring to that, all these jurisdiction, now or settle the settled position. 29,300. In the meanwhile, some interest must accrue. That they have to
We
pay.
don't even know if he has not sold it to somebody now. All these shop owners, they are not going to be in the same shop.
They cannot sell it
Somebody else
because they
will be
have to take
occupying.
permission from the they have to take permission.
Nobody takes. We know that what happens.
That is happening, minors.
Yes. Yes, sir. Are you prepared to deposit with the CDA the present market value?
Present market value 29,000 some odd has been demanded from me. After
when was it demanded, sir? Which year was it demanded?
98.
I'll take instruction.
What is that to take instruction? Your man will not. He will not be prepared to pay even this 30,000. Enjoyed a stay for how many years? 30 years now.
Just a minute. 2 minutes. Your lordship kindly bear with 2 minutes. Two category of plot has been advertised. One is outright purchase, one is installment purchase. I opt for outright purchase. I have deployed at a stroke the entire amount with the CDA. And final allotment letter in my favor and possession has been handed over to me. Thereafter, 1 year after, they issued a letter stating that the differential cost of rupees 29,000 is to be paid by me. That was under challenge before the Honorable Single Judge. And the other read application which has been disposed of is in the case of installment purchaser, not the purchaser who have purchased the land on outright purchase. And the case which has been disposed of by the Honorable Court is quite different from the case of the present appellant is concerned.
So the shop, all your shops to the same extent, all of them were sold for 99,300. That's the finding, sir.
That is the finding. That is on installment basis purchase, not on outright basis.
3 category and the price fixed for the same is 99,300.
That is the
17 shops had already been sold out of 23 shops at the same cost.
That is the installment basis purchase, not outright basis purchase.
Either way, sir, you have to deposit. You deposited what, 70,000? Now they asked you to pay 29,000. What was that?
29,000 from 1990.
Absolutely no illegality.
So this is the difference between the case decided and the present case is concerned.
If you want to take instructions on whether he's prepared to deposit the entire market value today, you find out. We'll prepare to, then you give you time to deposit the market value and you can get the shop. And you deposit today's market value, you should deposit. Only then you get the shop.
Let your lordship will keep this matter. I'll take instruction.
2 o'clock. 2 o'clock.
After action.
No such luck, sir. Difficult. Real difficulty.
In the meantime, they have demanded, that is that miscase, I have filed a miscase, that is 795 of 2018, wherein they have demanded with the interest, whereas due to non-payment of differential cost 29,300 in time, a sum of rupees 3,67,300 and
this is a lottery you've got. And you're still contesting this.
So that
you're still contesting it. Thank God you showed us that. Where is that affidavit? And you're not prepared to pay even this 3 lakhs.
Yes, ma'am.
You're prepared to pay.
That is that.
What is the CDA doing? For 3 lakhs, you're giving a shop.
What that I've been given.
I'm new to Orissa, but I know Cuttack market value of this must be much higher, sir.
Oh, it will be smooth and safe.
It's a luxury. And these persons are still contesting all this. IA 795 of 2018.
Page 5, my lord.
During
Annex
the pendency of the present writ appeal, it appears that the Cuttack Development Authority, CDA, has issued a letter dated 23rd October 2018 to the present appellant stating that it had earlier issued an intimation on 21st May 2018 requiring the appellant to deposit rupees 3,67,325 and rupees 71,490 by 30th June 2018 towards differential cost with interest and service charges. It accordingly informed the appellant by the said letter dated 23rd October 2018 that since the appellant had failed to deposit the above sums, he should show cause by the allotment of shop room number 38 of Bidanasi Market Complex Sector 6 CDA, which had been allotted by a letter dated 25th February 1995 and possession of which was delivered on 23rd March 1995 should not be cancelled. Paragraph. From the impugned order of the single judge, it appears that although the cost of the shop room allotted to the appellant was rupees 99,300, he had deposited rupees 70,000 and therefore was called upon to deposit the balance sum of rupees 29,300 by a letter dated 5th June 1996. This was challenged by the appellant by filing OJC number
10539/98.
10539 of 1998, which has been dismissed by the impugned order of the single judge. Full stop. By virtue of by the impugned order dated 22nd August 2014. So during the pendency of the writ petition, that was the status quo order, and that was continued in the present writ appeal by virtue of an interim order dated 4th December 2000. Consequently, the appellant has enjoyed possession of the shop in question throughout this period without having to pay the differential sum of rupees 29,300. So in the circumstances, the letter issued, given the current market value of the shop in question, the letter issued by the CDA on 21st May 2018 requiring the appellant to deposit a relatively meager sum of rupees 367,325 and 71,490 does not seem to be unreasonable at all. Full stop. Considering that it's in a commercial complex and a shop in a prime locality like CDA Sector 6, the appellant can have no grievance whatsoever. Paragraph. The court sees therefore no reason why it should interfere with the impugned order of the single judge. Paragraph. Considering that the appellant has remained in possession for all these years, a final opportunity is granted to the appellant to pay the aforementioned sum of rupees 367,325 and 71,490, along with further interest and service charges. That's right. Further interest and service charges as may be intimated by the CDA to the appellant not later than 1st November 2022 on or before 1st December 2022. It is made clear that if the appellant does not pay that said cost by 1st December 2022, it will be open to the CDA to take over possession of the shop in question.
The time. May I pray, my lord, time maybe end of December.
Sir, your luxury should not have granted even this time.
Small shop.
You find out from your client, which is why we asked you first to find out on telephone what is the value of that shop today. Then you will know the value. By a stay order, you've enjoyed how much interest is earned on that 29,000 for the last 30 years. Just multiply that 29,000 into even 6% simple interest. How much money you've earned?
That is correct, my lord.
The appeal is disposed of in the above terms.
23.
My lord, sir, there is a limitation. Lord, sir, because of illness, he could not file the appeal in time and he enclosed this medical certificate.
21 days. All smudged and overwritten, sir. There's a delay of 221 days, 221, right? In filing the present appeal against the impugned judgment dated 17th February 2015, the learned single judge. So the explanation given is that the appellant was suffering from jaundice between 3rd April and 31st October 2015. 6 months, nobody suffers from jaundice for 6 months. The medical certificate enclosed is not convincing. Consequently, the court is not inclined to condone the delay in filing the appeal. The application is dismissed. Consequently, the appeal is dismissed. Yes.
Item number 44.
None appears dismissed.
May I please mercy? On behalf of S. Mahanti, then no instruction.
No instruction is dismissed.
Item 45.
May I please, Lords? My lord, the appellant challenging the order passed by this honorable single judge under Annexure 11, page 48. My lord, initially, the appellant was appointed as a punishable CIS. He was involved in a criminal case on disciplinary proceeding initiated against the appellant, my lord. One inquiry was made. In the inquiry, there is no opportunity given the appellant. The final order was passed. The final order was under challenge before this honorable single judge. This honorable single judge passed this order with a direction to the appellant to approach to move the revisional authority in accordance with the law under page 60, my lord. Therefore, in view of the availability of the alternative remedy, this court is not inclined to interfere with the writ application. However, liberty is granted to the petitioner to move the revisional authority in accordance with the law. My lord, the petitioner was appointed as a constable under CIS rule. The inquiry officer was conducted the inquiry under Rule 34 of the CIS Rule 1969. Such inquiry has been conducted in the perverse manner, without complying the principle of natural justice and without giving the opportunity being had to the petitioner. More so, the petitioner has not given any opportunity to examine a cross-examination of the witnesses who deposed against him. No materials and documents which are utilized against him were given to him. In the meantime, the appellant was acquitted in the criminal case, my lord, under Annexure 4, my lord. Oh, sorry, my lord, under Annexure 10. He was acquitted. Now the appellant was falsely implicated in a criminal case. So, my lord, my lord, on para 9, right to invoke of Article 226 of the Constitution of
No, 1
India.
minute. The imputed order of the single judge relegates you to revisional authority.
Yes, my lord.
Now, what happened? Do you file the revision or not?
No, my lord.
Why? You should have filed the revision. By now, it will all be over.
No, my lord. As per the lordship's direction, the petitioner may be approved this revisional authority. I have not taken any instruction. So I pray lordship kindly taken up next week.
No, nothing, sir. It's only relegating you to revisional authority. What does that interfere? By the impugned order of the London single judge,
my lord,
it has been relegated to the revisional authority in respect to the order of the appellate authority. Full stop. That order obviously does not require any interference at this stage by this court. Full stop. In case the appellant has not yet filed the revision petition, time is extended up to 1st November 2022 to enable him to file such revision petition, with the delay being explained on account of the pendency of the present. Stop. In such event, the revisional authority will consider the revision petition on its merits and pass appropriate orders within a period of 3 months thereafter. No further directions are called for the triple is disposed.
Item number 46.
Appearance of the Union of Indian Mechanics.
Yes.
All right.
Item 46.
Delay. None appears dismissed.
Item number 47.
None appears dismissed.
Item number 48.
48, no instruction.
No instructions.
Lord, I am for the other.
No instruction.
I am for the, no, that is 643. There are two writ appeals, challenging the same order passed by the Honorable Single Judge.
All right. You're in 643. You're in 6. No, item 48. There are two writ appeals. You're in the first one.
First one.
643.
643.
Yes.
Now you are in 737.
737.
Yes, tell us. What's the delay?
My lord. 1 month, my lord, due to illness, my lord.
1 minute. Let's see. All right. Delay is condoned. Yes, tell us what the matter is about.
My lord, the petitioner has illustrate kindly come to the conclusion, my lord, page 7 of the impugned judgment, my lord. I have only modification of the order, my lord. The fact is like this. The appellant has been declared by the adopted son by a competent civil court, my lord. Thereafter, he filed up one Banchand Mahatra. He was one Mali Sebasi of the Laudukas Mahas Miller. She Laudukas Mahas Miller. Thereafter, Miller, in the year 1991, Miller, he filed a miscase to declare him Mali Sebasi and enjoy the properties enjoyed by late Banchand Mahatra, his adopted son, Miller.
Which order have you challenged here, sir?
Well, I challenge here, Miller, the order passed in WPC number 613.
Date, sir.
Miller. 613 of dated order 9/10/2015, Miller. Here, Miller, what happened, Miller? After I was appointed as Mali Sebasi, Miller, the Devatara, the sub-collector of Nayagar, Miller Devatara, he directed the SI, concerned SI of the to pay the.
So there has been no stay of the impugned order.
No.
So it has worked itself out by now.
No, there is not to stay, Miller, because only that I am not agreed by the entire order, Miller. I am only agreed by to give 50% to me and to 50% till the review petition and one writ appeal has been pending before this order till this Miller. So that's why I am inviting you also page 8, Miller.
Which
page 7, 4. 50% of
what
payment.
happened to this review petition 22?
There has been disposed of dismissed, Miller.
And then 323 of 2013?
323 of 2013 has been dismissed. And review petition 22 of 2005 has been dismissed.
Then what remains then? Nothing remains. See, by the impugned orders, by the impugned order, 50% of the payment was to be kept by the bark tenants, was to be kept in the recurring deposit. And till the disposal of review petition number 22 of 2005 or writ appeal 323 of 2013, whichever is earlier. Counsel, the appellant now informs the court that both review petition number 22 of 2005 as well as writ appeal 323 of 2013 have been disposed of. In that view of the matter, there will be no issue in releasing the balance 50% payment. Full stop. In that view of the matter, no interference is called for with the impugned order of the single judge. The writ appeal is right.
Item 49.
None appears.
Item 49 number, it has become infructuous. I'm for opposite party.
Anyway, none appears dismissed.
Item number 50.
None appears dismissed.
Item number 51.
My lord, in this case, we have already filed, my lord, IA for condition of delay. My lord,
how much is the delay, sir?
15 days delay, my lord, filing of appeal. And main order passed in terms of the order passed in writ appeal. It is already
3 days. It's already delays condoned. What is the IA number?
IA number 3131.
All right. What's the main matter about, sir?
Main matter challenging the order of single judge passed in terms of the judgment passed in 3459/2000 disposed of by this 17/3 to 15, my lord, allowed the writ petition and
Umakant Pradhan.
My lord, that
what happened to that Umakant Pradhan?
That Umakant stayed, but yesterday that was in the list in serial number 18. We are because of traffic, we came in late. My lord senior mentioned, but your lordship's not allowed the mention. Then we have filed
restoration
CMPL that has been already been stayed, my lord. Stayed in that writ of last.
Dismissed for non-prosecution.
Yes, my lord. That is that because of delay in reaching.
Whatever. Where has it been stayed? Therefore, as of today, it's dismissed.
My lord, if that will, I will file CMPL for restoration. Tomorrow we will file.
Whenever you file, sir.
My lord?
Whenever you file that, we'll take it up.
Yes.
You've still not filed.
That will be taken up with also your lordship liberty to file, take up this matter along with that petition, my lord.
What is the matter issue about?
Writ petition has been allowed and they have not in service from 2000 to 2015. But writ petition has been allowed and direction to pay all constitutional benefits like back wages was already.
No. In this case, was there any stay order?
This case has not.
No stay order. So have you implemented in this case?
My lord, that is that main order has been already stayed. Yesterday, your lordships dismissed this matter.
No. Here you have not implemented. No contempt petition filed here.
No, my lord.
So the respondent is not interested in the order.
No, my lord, they have not filed any contempt petition.
How can it be? This is for an order of reinstatement. They're not interested in their job.
My lord. The matter.
No, you're only to consider the case of the appellant in light of that judgment.
That judgment, your lordships yesterday dismissed for non-prosecution.
No, but here he has not filed any contempt. Then what are you aggrieved by?
We are filing challenging that same order, my lord.
No, but if the respondent is not aggrieved, so this is now 7 years now.
Yes.
If he is not insisting on implementation of the order of the single judge, what are you aggrieved by?
No, we are not.
He has not come forward to get it implemented. So why should you worry?
Yes, my lord. He has not also requisite not filed for communication of the order to the opposite party to in writ petition also. That is also.
Who's opposite party to in the writ petition? You.
No. Opposite party, not opposite party to.
The writ petition is you.
We are opposite party.
So he did not file requisite So obviously he's not. Why should we break our heads on all this stuff? Nothing will come out of these matters.
The matter we had along with that petition.
For what? If he is not even interested in implementation of the impugned order, why should we worry about it? What is his age now? How old is he? The order of termination was passed on 29th February 2000, sir.
Yes, ma'am.
Then he's been out of service for 22 years now.
Yes, ma'am. That his age is not.
He was 50 in 2000. He was already 50 in 2000, sir.
Yes, ma'am.
So now obviously he's not interested. He's 72 now. What reinstatement will be there? All this is infructuous. Why are you people pursuing this? You say the respondent was 50 years when he filed writ petition OJC 3458 of 2000, in which the impugned judgment was passed by the single judge on 8/10/2015. Now, how this could have been implemented also? Asking the present appellant to comply with the order in Umakanta Pradhan versus Orissa Forest Development Corporation. Order dated 17th March 2015 in OJC 3459 of 2000. Paragraph. It was perhaps not noticed that the appellant had already crossed the age of superannuation. The writ petitioner had already crossed the age of superannuation, and therefore there was no question of his reinstatement in service. Full stop. Not surprisingly, therefore, the writ petitioner does not appear to have filed any contempt petition asking for implementation of the order of the single judge in the last 7 years during which the writ appeal has been pending. Paragraph. With the writ petitioner being now 70 years of age, the question of his reinstatement in service cannot arise at all. Full stop. Consequently, the impugned order of the single judge cannot be implemented, and therefore there is no need for this court to interfere with it at this stage. The writ appeal is disposed of.
Item number 52.
Mechanically just being filed writ appeals. That's it. See the order of the single judge, file writ appeal. It will be pending, no, it will never come up here. Blank your minds. But for the single judge, mine is already 65 years and reinstated.
Number 53.
None appears dismissed.
Item number 54.
None appears dismissed.
Item number 55.
Memos taken on record. Dismissed is not pressed.
Item 56.
Memo taken on record. Dismissed is not pressed.
Item number 57.
May please
delay.
My lord, the appellant challenged the order passed by this honorable single judge under Annexure 7, my lord. What has happened, my lord? Initially, one advertisement was issued. In the delay 11 days delay, my lord. I am extremely sorry. Earlier, I have not said the 11 days delay, my lord.
Carry on.
My lord, one advertisement was issued on 30/12/2007 for the post of the Gram Rojogar Sevak. Petition, the appellant was applied. He was selected. His serial number is 2, my lord. Who was engaged as serial number 1? He was engaged. She was engaged. My lord, kindly see.
Sir, now you are what? How old are you now?
My lord, the single judge.
You are now 49 years old, sir.
Yes, my lord, I am 49 years old.
Out of reckoning completely. Gram Rojgar Sevak.
My lord, I was continuing.
No.
No.
Kindly see the impugned order, my lord, passed by the honorable single judge. Lord, what the incumbent was selected After having appointed.
My lord, I am for the petitioner. My learned senior arguing initially. It is very strange, my lord.
Why? He's supposed to be dismissed.
My lord, I am the appellant in this case.
Okay, let
Yes.
my learned friend complete it.
All right.
My lord, kindly see page 40 in the writ appeal.
Right.
In this case, the merit list was prepared in the year 2005, 2008. Engagement.
You had Upashastri certificate. You did not have +2 or intermediate.
Yes,
This
my
is
lord.
Not point.
Yes, my lord.
Ah.
My lord, kindly see page annexure 8, page 42.
Ah.
I was part in the +2.
Ah.
My lord, kindly see subject clarification of the equivalent certificate under annexure 8, page 42.
Yes. No, does the advertisement say equivalent?
That only +2 pass.
Ah.
Only
So
+2
it
pass.
does not say equivalent. You have to have +2.
My lord, kindly appreciate one thing. With reference to subject and your letter number such and such dated 8/7/2009, I am direct to inform you that the equivalent committee of the council has recognized the Upashastri course. Upashastri is +2 of Sri Jagannath Sanskrit Vishwavidyalaya Puri as equivalent to the humanities stream of higher secondary education Odisha, which was notified by notification number such and such.
What is strange, sir? It's a 2008 advertisement.
Yes, my lord.
Somebody resigns.
Somebody resigned, my lord.
In 2011.
2011.
And now
Then
my lord. How after 3 years you can be engaged? What is this new system, sir? You've never heard of something like this.
My lord, I am
You should have gone for a fresh advertisement. If there's a vacancy.
my lord, no fault. I am no fault, my lord.
Problem is, sir, if your appointment is illegal, no question of your fault. The whole process is illegal.
No, my lord, kindly see page.
Very strange. I've never heard of something like this.
Annexure 4, page 6, running page 15 to 21.
Right. All right.
The opposite party, opposite party number 5, prepared an appeal before the sub-collector. The sub-collector passed this order.
Advertisements usually say either have this degree or it's equivalent, right?
Yes, my
This
lord.
advertisement did not say equivalent.
Yes.
You only have Upashastri, you don't have +2.
Upashastri is the +2, my lord.
That is the advertisement has to permit that, sir.
Page 12, my lord.
Yes.
My lord, clause 3, my lord. Prati +2 parikya, intermediate parikya pass kartive.
That's what. It doesn't say Upashastri, sir.
Upashastri is my lord, +2, my lord.
Anyway, that's all right. You can keep saying that, sir. You can keep saying that.
Pardon, my lord?
You keep saying that, no problem. Yes.
No, my lord. There is a
Yes.
There is a government circular. There is the equivalent certificate.
Sir, the advertisement has to say equivalent, sir.
No, my lord.
Anyway, there's no problem. Okay, what is your next point? You tell us. What is your next point?
My lord, the option number 5.
How do you justify the 3 years after the advertisement you get appointed? I mean, somebody resigns. How do you justify that?
The petitioner number 1. Sorry, my lord. My lord, kindly page 21. Taking into consideration of the submission made by both learned counsel for the appellant number 2 and basing on the materials of the record, I am of the opinion that there is no illegality has been done in this selecting the opposite party number 2 as GRS, Gram Rozgar Sevak. Hence, the prayer of the petitioner deserves no merit. Hence, the resolution of the petitioner is rejected and the case is dismissed.
All right.
Earlier, the opinion number 5 prepared an appeal before the sub-collector passed this order.
So
that order was challenged.
Yes.
My lord, kindly see the annexure 5 is the counter affidavit
Right.
filed by the opinion number 5.
Forget counter, sir. First of all, tell us how 3 years after somebody's resignation, after 3 years, instead of going for fresh advertisement, you can be selected.
The learned single judge, my lord, passed this order.
You're not listening to the question. Okay. You're busy doing something else. He asked you a question. Are you answering the question or you're saying something else?
Yes, my lord, please tell me again.
All right. The present appeal is directed against a judgment dated 14th October 2015 passed by the single judge, allowing writ petition civil 19448 of 2013 filed by respondent number 4, is it? Manoj Kumar Nayak. No, respondent number 5, Manoj Kumar Nayak, thereby cancelling the appointment of the present appellant as Gram Rozgar Sevak, bracket GRS, in the office of the DRDA, Kendrapada. Paragraph. There were 2 grounds on which the appellant's engagement as GRS was cancelled. One was that the advertisement issued way back in 2008. 2007, all right. On 30th December 2007, required the applicant to possess educational qualification of +2 or intermediate. Full stop. The advertisement did not permit any equivalent qualification. Full stop. Admittedly, the appellant possessed only a single quote Upashastri unquote certificate and not a +2 or intermediate certificate. Paragraph. The second ground on which his engagement was cancelled was that one, Shubralin Nayak, who had been engaged as GRS on 11th July 2008, pursuant to the aforementioned advertisement, resigned from service on 3rd February 2011, and upon her resignation, the present appellant was engaged without going in for a fresh advertisement. Paragraph. On both the above grounds, the learned single judge is held against the present appellant. Full stop. As regards the qualification, counsel for the appellant contends that the single quotes Upashastri unquote qualification is equivalent to +2. Full stop. Considering that the advertisement did not permit a person having a single quotes equivalent unquote qualification to apply, but only a candidate having +2 or intermediate certificate. The candidacy of the appellant could not have been considered. Paragraph. As regards the second ground, counsel of the appellant is unable to explain how possibly the appellant could have been engaged 3 years after the selection was over upon the resignation of an incumbent GRS without going in for a fresh advertisement. Stop. Consequently, the court finds no merit in the present appeal.
My lord, one thing
and it is dismissed as such.
My lord, one thing I pray lordship, Upashastri is +2.
Item 58.
People not.
Yes, none appears dismissed.
Item number 59.
Item number 59 to 67. These matters have been challenged the order of the Honorable Single Judge. Similar matter has been fixed to 19/10/2022. Today, WA number 731 of 2015. In all these cases, I have to take instruction. This order have been implemented. I have to take instruction to that.
List on 19th. 59.
19th matter.
No, 59 to what? Serial number 59?
59 to 67.
To 67. List on 19th. All right.
Along with WA number 731 of 2015.
All right. Along with 731 of 2015. All right.
Item number 68.
Can you please, Your Lordship? I'm on virtual. The petitioner of Lordship was a candidate for IAC in their 2014, my lord. After the result was declared, he felt that he should get some more marks, applied in terms of for revaluation and re-addition of marks. No action was taken. Then in 2015, he applied through RTI, the entire mark sheet and answer script he got it, my lord. Then, my lord, issues even lawyer's notice, no action. Then file a writ application. Before lordship, let them produce the records. Minimum 2 marks, I will get the first class. I am entitled to 29 marks after I shown into the exports. Subsequently, now the order, the single judge has passed the order, page 19. Page 19 is the order passed by the single judge and against the order of the honorable single judge. Entire order free notice, everything is available through RTI with me now. And the ground I have challenged, what we will get from paragraph page 5.
When did you write the exam?
The examination was in the 2014.
You come in
I applied-
2016, sir.
No, my lord, I was applied the entire answer script in 2015.
Anyway, sir, by the time you approached this court, it was already 2 years.
It was already before the court. All the answer scripts were before the court, my lord, through RTI.
But it says it's not available.
The respondent says that it is not available. The authority says that it's not available.
Then?
Therefore, before lordship, because it is not latches on mine, because
No, where are the answer sheets? According to you, where are the answer sheets?
Answer sheets I have obtained through RTI, my lord. They say that no such answer sheets, original
No,
answer sheets are available.
So if it is not available, how do we make them available, sir?
That is my concern, my lord. That and I can
No. If there are no answer sheets from
answer sheets are available through RTI. I have obtained. I have also annexed all the answer sheets before your lordship. Entire answer sheets.
Where is
I
that?
have obtained 2015 onwards. Then I filed approached through a legal notice. I also approved. Then I approached the High Court. That there is a scheme for re-addition evaluation without attending my application. Without attending my application. Now they are saying the answer scripts are not available, therefore it cannot be evaluated, cannot be re-addition. Re-addition cannot be permission.
Which page is your answer sheet?
Entire, my lord. Please.
What are you now? What is the appellant now doing?
8 series, page 20 onwards. All, my lord. Every problem.
Sir, what is the
80 to
appellant
last
now?
page.
Mr. Mishra,
My lord.
your client was 19 years old in 2016.
Yes, ma'am.
What is he now doing?
Now, if you get 2 marks, my lord, can be career, he can make the career. 2
What
marks
career? You tell us what he's doing now.
Is the IT, is in the IT side, my lord.
He's already engaged somewhere, right?
Engaged.
So what is this 2 marks going to make a difference?
2 marks can get a higher because career marking.
What
is also
higher? What
considered.
career? Why should we say we shouldn't have academic exercise? If it will make a huge difference to his career, I can understand.
No,
If it's not going to make any difference, we leave it at that.
Well, 2 marks makes the career difference.
What difference? You tell us.
But
You're
why
such
you
a
are
wise
giving us-
person, Mr. Mishra. You're the wisest of the persons. What difference is it going to make today?
As a lordship pleases, my lord, what more I can advance? This is the fact for a lordship, my lord.
What, sir? What is the fact? You have to tell us today. What is your client doing? What is the difference it will make? You should tell
I have
us.
no personal, my lord, with all respect, I have no instruction.
You see,
What is being as on date, my lord.
the issue before the learned single judge was about re-evaluation of the appellant's mark sheets in the annual AC examination.
Yes, ma'am. HSC.
CHSC
Yes, ma'am.
examination bracket of 2014 bracket science stream. Full stop. The appellant was short of 2 marks for securing first division. Full stop. The learned single judge noted that the answer sheets were not available and dismissed the writ petition, which had sought revaluation of the answer sheets. Paragraph, according to the appellant, the answer sheets were available and he had obtained them through RTI. He has enclosed all the answer sheets purportedly issued to him under RTI Act. Paragraph. The appellant was 19 years old when he filed the writ petition. Full stop. He has already progressed in life, perhaps employed somewhere now. Full stop. When asked what difference would it make to the appellant's career prospects, Mr. Mishra states he has no instructions. Full stop. If the issue has become purely academic, then the court should not, at this stage, examine the correctness of the impugned order of the single judge. Full stop. The appeal is accordingly disposed of. Right.
Item 69.
So item 69 stated, Lordship, come to page 7. I have quoted the proviso of the section 3 of the OGL Act, Lordship. Page 7, Lordship, just first paragraph, Lordship. Provided no government land recorded as gochur shall be reserved for any purpose mentioned in clause A or settled under clause C without being deserved in accordance with law, provisions contained section 3A. Then
Any representation is there. Email. These days, representation are only by email, sir.
In fact, Lordship, Annexure 2 is the Lordship consequence. They have given the reason order there, Lordship. On email, Lordship, that was representation. A Lordship can say Annexure 2, page 15. They have replied, Lordship.
What have they said?
Lordship, just I'm reading, Lordship. With reference to the subject cited above, I am to say that complainant petition of Rakesh Roshan, a village Krishnachandrapada, has been duly inquired by the local RI Adampur and his report as follows. Messrs. KS International Private Limited undertaken the work of laying pipeline for supply of water rural people, and the same work has been authorized by the Government of Orissa RWSS department. The materials are kept over the khata number such and such, Kisam Gochur Lordship, village Krishna Pada under Rasul Tahsil. The authority, Messrs. International Private Limited Authority, has not obtained permission from the competent authority. However, the Messrs. KS International Private Limited Authority assured the Tahsildar after completion of the work, the material stocks over the land will be shifted to any other place. Further, the Messrs. KS International Private Limited has been directed to take permission from the undersigned with requisite rents. This is more devastating, Lordship. When the place is not permissible to use in other purpose, the statute says, he is going to.
It's only a temporary thing, sir. For laying pipeline, they're putting.
But Lordship, he is using the Gochur land. That is objectionable land, Lordship.
Everything you do not.
Lordship, kindly see the provision.
All right. We need not interfere in every matter like this.
Not every matter, Lordship. Lordship, these officers cannot throw away the provisions of law.
It's all right.
Lordship, kindly see that. Just 1 second, reading the provision, Lordship.
All right.
There is a complete prohibition
All
for use of Lordship. 1 second, reading. I have quoted.
All right.
Section 3.
Everything you rush to court with everything, sir. That's
Lordship, no, Lordship, we have not rushed to court. We have rushed to the collector first, Lordship.
No,
Lordship,
fine.
Lordship, they are justifying their illegal action. It can be cured by the collector, Lordship.
All right.
Had it been cured, there is no other occasion to approach your Lordship. Because we have approached before collector, and if Lordship see the reply of the collector, Tahsildar, he is justifying his illegal action.
Right. It appears that the work of laying of the pipeline is a temporary. It's only and the storing of materials for that purpose is a temporary phenomenon. Would stop. The reply given by the Tahsildar indicates that without permission of the Tahsildar, the situation cannot be allowed to continue. So with that view, the matter no further directions are called for. The petitions disposed of. All right.
But Lordship, one more submission, Lordship. I am not on the Lordship. Lordship lightly pointed out that required permission. But Lordship, in the second sentence, he is now giving permission with receiving the rent.
It's all right. It's only temporary. All right.
Item 70.
Temporary also not permissible, Lordship.
All right.
Item number 70.
70, 71, 72. 3 items. No?
Yes.
All these things may be tagged with item number 91 because that RERA matter. 90.
Yes. Okay. We'll take it up with 91. All right.
90, my lord. 90.
93. All right.
Item number 73.
None appears dismissed.
Item number 74.
May I please? Your Lordship,
Delay. What's delay, sir?
delay matter after COVID matter 2 months. 88 days delay after COVID, after 1/6.
So the same thing, rehabilitation assistance scheme.
What has happened in
Canara Bank.
Yes, madam. What has happened in this case? Your Lordship, kindly see page.
A whole bunch of matters now, sir.
What has happened? He has applied in pursuant to 2020 rules. Thereafter, the Honorable Court had directed to consider his case in accordance with old rules. Lordship, you can get it from page 32.
Anyway, when are these matters coming up? The RAS matters, this whole batch, sir.
Yes, madam. That is, Your Lordship, 375750 of 2020.
No, when are they coming up?
It has been urgent for sign day.
But here notice will have to go and then it can go sign day. Here, have they filed any contempt?
Yes, ma'am. He has filed a contempt.
All right, notice on the delay, writ appeal, and stay.
3228 of 2020 contempt filed.
All right. Is it till the returnable? 14th December. Till the next date, there should be a stay of the implement order.
Item 75.
See, 2 other matters are also same. 75 and
76, yeah, same.
Supplementary list item 77.
Even yesterday it was on board.
Yes, taken a Passover last. Paper book is ready, ma'am. Paper book is ready. So
That's what. Is the board correctly reflecting 77 item 77? Yes. Passover.
Item number 78.
28 for, if I may please your lordship, I'm appearing from DC, my lord. My lord, an application for bail has been filed, my lord, for more than 9 years in custody, circumstantial evidence, my lord.
Paper books are not ready.
My lord,
paper books not ready. Deposition copies also we don't have. So
my lord, it was called for, it has also not come, my lord, unnecessarily, my lord, for more than 9 years she's in custody, your lordship, my lord.
What do you say?
My lord,
yes, my lord. This is wife has allegation is that she has killed the husband. She had absconded after an allegation the informant father.
Right.
They were always quarreling, and one night she had
has already undergone 9 years of custody.
My lord.
All right. This is a case based on circumstantial evidence. It seems unlikely that the appeal will be taken up for hearing in the immediate future, particularly since paper books are not yet ready. Even keeping in view the appellant is also not known to have any criminal antecedents. Keeping in view the above factors, the court directs the appellant to be enlarged and bail during the pendency of the present appeal, subject to the satisfaction of the trial court. This IA is disposed of. There are 2 IAs, right? It's the same relief.
And one was for stay realization, my lord, that has been allowed, my lord.
on 8/9/2022.
No.
Stay relation of file, your lordship allowed on.
No, that's right. There is another IA 912.
Hello, 912 is stay realization.
The 911
is for bail, your lordship.
That's what. So put down both 911 of 2018 and the 648 of 22. Both are disposed of. In the main appeal, you say paper books be prepared within 8 weeks and supplied to counsel to the parties. Thereafter, the appeal be included in the list of final hearing matters. All right.
Extremely good, your lordship.
Item 79.
May I please?
The TCR be requisitioned once again, and therefore.
May I please?
Yes.
My lord, so far the case of the present petitioner is concerned, this is a better case than the just previous one. This petitioner is in custody for about more than 10 years by now. And the entire circumstantial evidence is against the petitioner, and that is also very weak. He has been convicted under section 364A, but my case is that he has been convicted by taking 34 only, and for 34 there is absolutely no evidence of common intention. He at one point of time he gave company to the deceased from, you'll also kindly see the for a moment, page 7 of his judgment. He was picked up. He is virtually an idiot, can be said to be an idiot spectator or the companion of the main conspirator. In page 7, it has been stated that therefore the accused person Dilip and Krishna Chandra Behra took the deceased to via Bhubaneswar, that is from Ganjam, in one Indica car, and on the way at Bhubaneswar, accused Pramod Behra joined them.
All right. You say the appellant is stated to have already completed over 10 years in custody. The case against the present appellant is based on circumstantial evidence.
My lord, almost 8 accused persons had, so there must be some connected appeal also, my lord. Only one appeal has come.
I'm not concerned with them.
And no, because he has been identified. Right?
No,
He has been identified in the TI parrot because this is 360 for kidnapping for ransom death, my lord. So they have these main accused had allured this person to give a job by taking money. And when he did not return money, on the pretext they have kidnapped this informant's father and they have killed him.
Those are other people, not me.
No, that's right. That is what I'm saying. He was his complicity, my lord. He was there.
Which are the connected appeals? Which are the connected appeals?
Connected appeals, my lord.
If that would have been, probably that would have come along with this. Probably because
There are, my lord, because there must be, because Dilip, all these persons are in custody. Dilip Acharya, Deepak Kumar Acharya, they were all custody, my lord. So
you find out which are the connected
yes, I'll find out, my lord. Your lordship will grant a short date, I'll find out.
The learned additional government advocate will produce the list of connected appeals and list this appeal along with the connected appeals on 3rd November, Thursday. Meanwhile, the AGA will also take instructions on the criminal antecedents of the present appellant for the purposes of considering the application for bail. Right.
Yes. Right. So, my lord, why I said the better one? This I submitted that he was picked up on the way by the accused. He didn't know anything.
All right.
To accompany him only to Puri, and again he was left at Bhubaneswar. He doesn't know neither at the spot of killing, nothing, or demanding. He didn't know anything. Entire evidence. I don't mind.
All right. Meanwhile, the appeal should be admitted, no?
Technically should be admitted. It's not admitted.
Criminal appeal, main criminal appeal. You say admit the trial court record be requisitioned.
No, record is there.
Paper books be prepared within 8 weeks and supplied to counsel to the parties. And in that IA, you say list on 3rd. This is stay of fine.
I filed only, I think, for bail only.
Yeah, 238 of 2019. You say that one. And 1179, what is that, sir? Interim bail, that must be infractuous.
Infractuous.
1179, disposed of as infractuous. All right. Right.
Supplementary list item number 80.
May please, your lordship. The appellant is in custody more than 14 years, my lord.
14 years,
my lord. In my lord, I supply the copy of the deposition also.
You see 1336 of 2022. What is this based on direct evidence or circumstantial?
My lord, circumstantial.
PW 8 and 9 have seen, my lord.
Last scene.
But my lord, my humble submission is lordship that way
14
short.
years.
My lord,
14 years. You
these
say.
are, my lord, if I'm not mistaken, they're hardened criminals, my lord. They have number of antecedents to their.
Then you find out. You see,
Then, yes.
IA number
So I was
1336 of 2022, Counsel for the Learned AGA wants to take time for ascertaining the antecedents of the present appellant. At a request list on 17 November. All right.
Lord, I may be excused that 79, Act number 79, I have given the supply the copy of the deposition to my land counsel for the state.
All right. All right.
That is already supplied in the last week.
All right, sir. All right.
My lord, 27 November.
17th November.
My lord,
Item 81.
Your Lordship, we look to your Lordship's order dated 29/6/2022, order number 13, the last occasion. Lordship.
I am the petitioner. Lord, I am the petitioner in this case.
Yes.
My lord, on last occasion, the counsel for the opposite party number 8 has submitted a document before the honorable court and relayed the judgment stating that 2018-10 SCC 312. I was under the bona fide belief that the judgment has been given to the honorable court. But to my good luck, now the live streaming has been ordered by your lordship, for which I am able to what happened on the last occasion. Actually, they have given some document or has a petition to the honorable court stating all these judgments, for which the honorable court has directed me to examine this and argue on the next case. But I have not seen the petition which has been provided or submitted to the honorable court. Let them give that petition to me so that on the basis of same I can argue what is the case maintainability. They have not given on last occasion.
Not the petitions, only the copy of the judgments has been handed over to your lordship. The writ petition is not maintainable in view of these 4-5 judgments.
You give the citation copy.
That is a
They have cited, they have to give me that.
No,
that has been a reflection.
Sir, in the order,
my lord,
we've given you citation, the complete citations.
That I understand. But the thing is that
it's good you understand, sir. So you just have to start reading those judgments.
No, there must be a fact. There must be a fact to substantiate the judgment.
No.
But they have whatever document they have given, they have only relied on the last occasion 2018-10 SCC 312. Only relied on this. Advocate for the opposite party number 8. They have not stated this Palghar Jilla or Sirish Kumar Chaudhary of state of Maharashtra, which your lordship has in the court has the order. That means they have given something which I have not been provided. I want that copy.
Sir. These are all judgments.
These are judgment on the basis of certain fact. They have relied this judgment.
No. You just read those judgments. You'll know what the judgments are.
You like place that judgment?
No. Placing of the law. They have given certain document which I must have a copy so that I will argue on that.
May I just intervene, my lord? May I just submit? I will only argue on the writ petition itself. I will not refer to any other document. My lord, may kindly see the prayers in the writ petition. I will not refer to anything else but the writ petition.
My lord, he has not been allowed as interpreter till date. He is arguing the case.
As an officer of the court, let me bring it to the notice of the court.
He may say, but after we are arguing, officer of the court will say, people stating, he should state that I will, as an officer of the court, he started proceeding. And this way that is going on, as happened on last date, I was bulldozed by all of them at a time. So that I am confused on last occasion. That what happened in the court.
My lord, let him come with ready and let him go through the judgment and next day we will see. Next day we will
My lords, when we are raising maintainability, I'll just draw my lord's attention to the prayer. I think that I am entitled.
ଆଉ ଦିନ ଆସୁ ସେ ନିଅନ୍ତୁ ତାଙ୍କୁ ଗୋଟେ ଦେଇ ଦିଅନ୍ତୁ କପି
ଦିଅନ୍ତୁ
Judgment ଯେତେବେଳେ cite କରୁଛୁ copy କଣ ଦବୁ?
ନା ନା ସାଇଟେସନ ଟା
Citation ଦିଆହେଇଥିଲା. Court has passed the order in citing.
that document must be given, there must be prayer. This has not been stated in counter affidavit as well as additional affidavit filed by them. But they have every right to file
May
any
I have
petition.
just have a couple of minutes if my learned friend would allow?
No.
I am raising maintainable.
If you are not party in this case till now, only court allow, then thereafter you will argue. You will argue.
Maintainability, my lord.
My respectful submission is that your lordship may direct the petitioner to examine the decisions which your lordship has referred in
You
the
already
last
said
order.
that last time. Sir. We already
And
said
then
we
next
set
step
out
you-
the judgments and citations.
No, he is
This-
saying that he must get the copy.
Why? Who says? Suppose his question of maintainability, he has a library here, sir. The High Court has a very good library. So why does he need copies of judgments?
It may come after
Yes.
vacation.
This writ petition is not maintainable, my lords. On the face of it, on the documents annexed to the writ petition, I will not refer to anything else. My lords may kindly see this question came up before this court. The parliament has accepted the judgment of this court. Now they want to review the entire thing. Something which has been accepted by the parliament.
Not memo. There's no question of memo now. Give back. What is this memo?
My lord, what documents they have given, I do not know.
Sir,
That's why I am
Mr. Sethi,
kindly consider.
Mr. Sethi,
My lord,
the order passed by us gives you a list of judgments with citations. Nobody, it is not incumbent on anybody to supply you copies of those judgments.
I am not. I am
You
not
are simply
asking.
to just listen. You are simply to read those judgments and tell us your submissions in relation to those judgments. Yes. Please proceed.
My lord, let them first state how this judgment is going to go.
Sir, if you do not want to argue anything further, we will reserve our maintenance.
No, my lord.
Please proceed to deal with those judgments and tell us whether those apply.
It's not.
Please.
My lord, they have mentioned Bir Singh versus Delhi Jal Board.
Yes.
2018 10 SCC 312.
Correct.
They have not stated anything how it is applicable.
Forget, sir, please tell us whether the judgment applies, doesn't apply. Yes.
I am telling, I am coming to that. There, your lordship has mentioned para 32 specifically. Para 32. Para 32. Para 32 says that in Mari Chandrasekhar Rao, the Constitution bench observed that expression in relation to that state must be read meaningfully and harmoniously. It was observed that if a member of scheduled caste and scheduled tribe gets the benefit of that status throughout the territory of India, the expression in relation to that state would become nugatory. If the special privilege or the rights granted to scheduled caste or scheduled tribes in a particular state are to be made available in all the states, and if such benefits are to be carried from state A to state B on migration, the mandate of Articles 341 and 342 get compromised. Such a consequence must be avoided, for it is a fundamental rule of interpretation, be it statutory enactment or of the Constitution, that wherever there is a conflict between two provisions, the same should be interpreted so as to give effect to both. Nothing is surplus in a constitution. No part should be made nugatory. How this is going to affect in my case, I could not understand. It is neither the direction or observation of the court. It is a case law cited in another case. But they want to state me that explain how it is going to affect. Let them say that how it has been affected. And let me complete my explain. Let me complete.
32, that is paragraph 32.
I am reading paragraph 32.
No, that Manupatra is 32.
That is paragraph 36, your lordship, and kindly have it.
That book also lordship look to that.
See, my lord, they are referring Manupatra, but they have referred the case law 2018 10 SCC 312. Now they are telling that it is paragraph 36. If this is the manner in which they are confusing me, then how I am prepared and I will come to argue on the case. Then let it be adjourned. If they are telling some other para, then I will examine that.
Mr. Sethi,
my lord,
I'm telling you for the last time,
my lord,
change your very attitude of arguing like this. All right.
My lord, I am
please be serious about your case. If you want to read some more paragraphs, please read it.
My lord, I am
Please
prepared.
make out your case for maintainability. Yes.
I am prepared on para 32, which was mentioned here.
Sir, please, this is not some classroom. This is not some exam.
Obliged, I'm obliged.
Carry on reading. Carry on reading. If you have some other paragraph to read, please read it. Yes.
My lord, I may give in one chance to explain this. Let it be adjourned to another date. Let it be adjourned to next date or 1 week after. Because now I am to prepare what is in para 36. Now they is telling it is in para 36. I am prepared that para 32 does not have this sense.
Mr. Sethi, you cannot take this court for granted.
No, my lord.
And you cannot waste. Please do not waste the time of the court like this.
In the time of the court, my only prayer is that I will go through the para 36. Now they have changed the.
Sir, don't just go from para to para. This is not how lawyers argue cases.
My lord, that is
Mr. Sethi.
My lord.
Kindly conduct yourself properly in this court.
My lord.
And be serious about your cases.
My lord.
You're not supposed to just be reading 1 para and 2 paras. You're supposed to read the entire judgment. You're supposed to understand what the judgment says and then make your arguments.
My lord. Obliged. The para 36, the offset of the aforesaid decision would lead us to the conclusion that the presidential orders issued under Article 341 in regard to scheduled caste and under Article 342 in regard to scheduled tribes cannot be varied or altered by any authority, including the court. Nobody can alter that what has been done by Parliament. It is the alone which has been vested with the power to act that too by laws made scheduled caste and scheduled tribes thus specified in relation to a state or union territory does not carry the same status to another state or union territory. Another state, it is not related to that state. Any expansion, deletion of the list of the scheduled caste or scheduled tribes by any authority except Parliament would be against the constitutional mandate under Article 341 and 342 of the Constitution of India. Here it clearly says that what is to be done by the Parliament, not by the court or any authority. That what they say. That is exactly my case, my lord. What happened in my case is that is what my case is. What happened in my case is, kindly just go through the writ petition. Running page 30, 31. Running page 30. Here it is. This is the Lok Sabha introduced in Parliament on 31/8/2001. Our case is entry number 24. Substitute Diwara, Dhibara, Keuta, Kaivat. In the next page, it has been mentioned modification in the existing entries in accordance with the directives of the Honorable High Court of Orissa in the case of Narayana Behera versus State of Orissa. And the Supreme Court in Bhaya Ram Munda versus Aniruddha Patra.
Yes.
That is exactly our case. That court cannot come into picture to help anybody else. That is where our case is. That they can amend it. There are certain modalities. That is modalities I have mentioned in my writ petition along with the rejoinder. There is a modality that state government, that the same has to be forwarded from state government, National Commission for Scheduled Caste and Registrar General. All of them give a proposal to the Government of India. Thereafter, it will be amended. Instead of following the procedure, they have relied the judgment of the Honorable High Court of Orissa in the case of Narayana Behera versus State of Orissa, which is no more, with greatest respect to this Honorable Court, the said judgment is no more valid on the said date, as that has been superseded by another judgment of this Honorable High Court, as well as by the Supreme Court, that no direction can be given to government regarding inclusion of any caste, whereas in the case of Narayana Behera, this direction has been given. I am submitting the case law of Narayana Behera on the basis of which this amendment has been made. Narayana Behera judgment other one. That is.
Page 499 of the brief. The judgment is already there. Page 499.
In this case, Narayana Behera versus State of Orissa. This is the case on the basis of which the amendment has been made in the parliament. There the Narayana, in the case of Narayana Behera versus State of Orissa. It has been challenged that the caste certificate issued a particular person, whether he belongs to Diwar community or not. That was the challenge. And there, the Honorable High Court, relying the decision of Bhaira Munda and others, has made it clear that we are inclined to accept the petition stand that he belongs to Diwar community. I am reading paragraph 5 point of the order. We are inclined to stand that he belongs to Diwar community, and the collector of Puri had rightly given in the when Justice Ranganath Misra then was, but subsequently, in the case of Shirish Kumar Chaudhary, which relied by the Shirish Kumar Chaudhary, which relied by them, I am referring to Shirish Kumar Chaudhary, the Supreme Court. It is a 3-bench judgment, full bench judgment of the Honorable Supreme Court, wherein Justice Ranganath Misra, as he then was, he was judge of the Honorable Supreme Court. As he then was, has passed the order. Wherein at page 3, 4th line, in his application in a representative capacity before the High Court, he maintained that he belonged to Laskar community, which he had always been treated in a erstwhile state of Tripura as a scheduled tribe. And on that basis, in the state records, was included that Desi Tripura community long before the integration of the rulers of state of Tripura with Union affiliate. This is the issue which has been taken into consideration by the Honorable Supreme Court in the case of Shirish Kumar Chaudhary. At page 12 and 13, para 20 of this order. 2 constitutional benches judgments indicate that inquiry is contemplated before the presidential order is made by any amendment to the presidential order can only be by legislation. We do not think we should assume the jurisdiction and enter into an inquiry and determine whether the 3 terms indicated in the presidential order include Desi Tripura, which covers the Laskar community, but we consider it appropriate to comment to the authorities concerned as and when the question is reviewed, it should be examined whether the claim of the appellant representing the Laskar community to be included in the scheduled tribes is genuine and should therefore be entertained. There the court declined to include the Laskar community, but because the Honorable Supreme Court has told that we don't have any authority, but we are recommending that they may consider it. That is what the case is. Thereby, the judgment of the Narayana Behera has been superseded, which also no direction has been given. But presuming that any direction has been given by the judgment of this in the case of Shirish Kumar Chaudhary, 1990, the full bench of the Supreme Court has overruled the same, all the things that court cannot direct any caste to be included in a particular as a scheduled caste or excluded as scheduled caste. It will only see the validity of the amendment made in the parliament. It cannot direct that you include it. It is similar to that one. That what has been done in the case of Narayana Behera, on the basis of which the amendment has been made in the parliament. Had the parliament amended following the procedure that has been laid out by its guidelines in the year 2001, we don't have a case. We have only case when they have made amendment only on the basis of judgment in the case of Narayana Behera, which is no more validity on the eyes of law on the said date, nor any direction has been given to the by the Honorable High Court to include the Diwar community as Diwar community as or Diwar Keuta as scheduled caste. Therefore, this action taken by the in the president sort of in the parliament is contrary to what the law is existing at that point of time, for which such action is totally illegal, and thereby the community, we are not objecting that any community will be included or not. They can be included in the procedure that has been laid down, modality that has been laid down, which has been accepted by the opposite party in their counter affidavit. The government of India
in their counter affidavit fully admit that they have committed that wrong by including it only on the basis of direction given by the High Court. They have not followed the due procedure. That is what the counter affidavit of the state government says. State government as well as central government says. Both the state government and central government, their counter affidavit admitted to have done such wrong thing because they have done only on the basis of direction given by the Honorable High Court of Orissa, which they don't have any control. That is what is their argument.
Where is that?
They never stated.
Where is that admission in the counter? Which counter?
Counter of this center. I'll. Center of the counter of Orissa. My lord. Running page 44. Counter running page 44. Central government counter at para 6. The ORJ has examined the state government of Odisha proposal on Diwar a number of times, and at that the ORJ has all the times agreed to delete the entry Diwara at serial number 23 in the scheduled caste list of the state. They have agreed always to delete this Diwar caste, which is no more prevalent in state of Odisha. This Diwar community, which was existing prior to independence, a nomadic character, they after creation of the state of Odisha, this nomadic community having 1,500 population have left Odisha and migrated to Madhya Pradesh. This and Madhya Pradesh. And for which not a single person for Diwar community is existing in Odisha on the basis of this for this nomadic tribe. They have admitted this in para 6 as well as the next page 45. But this office would like to reiterate in para 8, last 4 lines. Reiterate that the view of the ethnic identity of Diwar being different from Diwar and others. They have specified that Diwar, these communities, Diwar and others, in the names of Diwar, Devara, Keuta, Koibarta, etc., should not be accepted as synonymous of Diwar as requested by the representation. They have mentioned in their counter affidavit. Thereafter, at para 10, running page 45, last 4 line, and the ORJ provided its dual letter number so and so, one its earlier stand, they stand for exclusion of the community from the scheduled caste list of the state. The ORJ mentioned that this office supports not only exclusion of Diwar, but also the deletion of Dibara, Keuta, Koibarta as synonyms of Diwar from the scheduled caste list of Odisha. This is the counter of the Government of India as well as Registrar General of India. Both the Government of India and Registrar General has given.
No, that is RBI counter.
If your lordship permits me,
OP2.
It is not OP1.
if your lordship.
What he's placing is probably OP number 2's counter.
Yes.
But referring to
My lord.
ORGI.
My lord,
Yes.
my lord, I am coming. That is, they have filed a miscellaneous case. Government of India has filed a miscellaneous case number 10,383 of 2014. 10,383 of 2014. They have filed a miscellaneous case on behalf of opposite party number 1 and 2, Union of India, wherein
We want to file a counter.
My
They've
lord,
asked for time for counter in that.
We have not filed counter, I think.
They've asked for time for counter.
who will file counter?
Is it?
I am reading the counter of central government. That is the counter. I am miscellaneous case.
This miscellaneous case is for file counter.
For OP number 1 and 2. That is what.
Counter has already been filed. What is the purpose of placing this?
My lord, this miscellaneous application has been filed in the year 2014 on behalf of OP number 1 and 2 by the Registrar General, this Prabhakar Barad, who has filed final counter on behalf of all the opposite parties. He has mentioned it at para 2 of his counter that I am acquainted with the facts of the case and authorized to swear affidavit on behalf of other opposite parties
All right.
That means he has filed on behalf of the government of India also,
All
while
right.
he has taken time for both opposite party 1 and 2.
All right.
Now, therefore, this they cannot oblige. They themselves, the government of
We'll
India,
continue after lunch, sir. We'll We've appointed Justice A.K. Patnaik, former judge of the Supreme Court. Yes, court. The petition is disposed of.
Continue. My lord, the opposite party number 1 and 2 in their counter affidavit has annexed certain documents. That is annexure B/2, running page 49. That is the modalities for inclusion or exclusion of the scheduled caste and scheduled tribe. This is the modalities approved by the government of India for deciding claim for inclusion and exclusion, and other modalities in the orders specified in scheduled caste and scheduled tribes are enclosed for your kind information. The modalities has been drawn, which has been used by the opposite party number 1 and 2 in their counter affidavit dated 30th August 1999. It is before the amendment made in Parliament. There in the next page, they have annexed in 50. The modalities has been mentioned, case favored by both the state government and the Registrar General of India in their most recent reports would be reported to the National Commission for Scheduled Caste and Scheduled Tribes.
Anyway, there's no need to read the whole thing. Basically, they work on the modalities.
I'm not reading whole thing. I'm just highlighting the important things for their opinion.
All right, sir. Why don't you make your submission? Basically, these are modalities.
Then these modalities is that these are the important things has to be followed before.
All right, and they have not followed it. That's your point.
No. What is the state government, Registrar General of India?
See, your point is these modalities have not been followed according to you. Anyway, that point is taken. Yes.
Obliged. Then they are at running page 55. Annexure C/2 in their counter affidavit. That is written, continuance of educational and economic and vocational concession to the members of Diwar community of Orissa. This is a government of Orissa letter. They have relied. In para 3, as the ministry is aware, on a reference from them, this office had made a detailed inquiry in regard to ethnic identity of the Diwar.
They have actually said how these should not be part of the SC, correct? This whole letter is 1979 letter, sir.
There they have mentioned that
correct. They should not be.
Communities should not be. They have this.
All right.
Point is state central government who has made the amendment in Parliament has admitted that their modality has not been
correct.
Then annexure D/3 running page 58, which they have enclosed. That is 2001 August. I am reading 1, 2, 3, 4, 5, 6, 7th line.
Yes.
Below. The recent ethnographic information and also the brief notes prepared by Professor Sinha of the JNU have been constituted in the service. Since no additional ethnographic information on reference communities are noticed, no addition is proposed in the comments. In the next page, 59, there it is this office agreed to the proposal of the exclusion of the Diwar from scheduled caste list of Odisha. This is in the year 2001, August 2001. That is the reference given by the Registrar General in their letter. Running page 59, XII 12. There it is mentioned, this office agreed to the proposal of exclusion of Diwar from scheduled caste list of Odisha, Annexure XIV, serial number 678 and Annexure XIVC. That is what mentioned in their document. It is not mine case. It is there, they have relied. Thereafter at page 61, Annexure 4B, Para 2, Government of Odisha has been requesting exclusion of Diwar community from the list of scheduled castes on the ground that the members of this community are not found in Odisha. This is important. Diwar community is no more found in Odisha, original list on which they are claiming to be synonymous. ORJ and the National Commission of Scheduled Caste have also concurred in the proposal of its deletion, via their letters under reference. As the synonyms of Diwar, namely Divara, Keuta, Koibarta, are also included in the existing entry number 24, along with Diwar. Therefore, before proposing the proposal further, it has been decided to obtain views of the ORGI on the point whether the main community can be deleted from the scheduled caste, leaving its synonymous in the list of scheduled caste, or the whole entry ought to be deleted. That is subsequently. They have relied. I am not relying. This is what they have relied. And they, at running page 63, modification, serial number 4, modification of list of the SC/ST on the basis of Supreme Court, High Court rulings. Serial number 4, that is the heading. And thereafter, in Odisha, it is coming Diwara with Keuta Koibarta at running page 67. It is only on the basis of the judgment of the Supreme Court or High Court rulings. That is what they have mentioned. They have also enclosed another document wherein Government of India, running page 68, National Commission for Scheduled Castes and Scheduled Tribes, on 2001, 6th November. It is on behalf of the National Commission for Scheduled Castes and Scheduled Tribes. There it is specifically mentioned that I am directed to refer to DO letter number so and so, dated 9/8/2001, addressed to Joint Secretary in this commission on the above subject, and to say that the proposal were discussed in the commission's meeting held on 3/10/2001. Views of the commission on each proposal is sent herewith in the extracts from necessary action at your end regarding proposal for Odisha case. And it is next at page 69, heading number is 4, exclusion of Diwar from the state of Odisha. This commission has concurred with the proposal of deletion of Diwar from the scheduled caste list. Similarly, at page 70, they have again mentioned deletion of Diwar from serial number 24 of scheduled caste list. That is serial number 35. Then again at 74, again the same is mentioned, deletion of Diwar at serial number 24 of SC list. Then at 75, this office agreed to the proposal of exclusion of Diwar from the list of Odisha under Annexure 14, serial number 678, Annexure 14C. That is, they are proposing to delete the Diwar. Forget about the addition Divara, Keuta, Koibarta. That is, they are claiming synonymous, which is not. Thereafter at page 76, Office of the Registrar General, उपायुक्त विषय पर आपके तारीख 13 जनवरी 1993. This is 1993, and at the next page 77. This is 1993 letter, Diwar 678. To exclude from scheduled caste list of Odisha. In an earlier communication, no Ministry of Home Affairs, in an earlier communication to Minister of Home Affairs, letter dated 15 January 1979, this office had indicated there is no genuine community by name Diwar. They are questioning the very name Diwar in which they have added. They are stating that no Diwar community exists in Odisha. Lokur Committee 1965 had also observed that there are no Diwars in Odisha and the persons of the fisherman caste, also not untouchables, are returning themselves as Diwars. They are mentioning. In view of the above and in view of the state government's recommendation, the proposal to exclude Diwar from the list of scheduled caste in Odisha may be considered favorably. They want to delete it accordingly. Thereafter, Annexure E2, running page 78. It is 2012. They have enclosed the Government of India. In view of the comments detailed in the annexure, this office supports deletion of Diwar, Dhibaro, Keuto, Koibarto from the list of scheduled caste from Odisha. They have enclosed. It is not my case. It is their case. What they have taken stand before this honorable court through their counter affidavit. Now coming to the state of Odisha affidavit, counter affidavit. What they have stated in their counter affidavit. Opposite part number 4 and 5. State government. Running page 403 of the court page.
Yes.
Para 8.
They also agreed to deletion.
My lord.
They also agreed to deletion.
They also agreed.
You don't need to read the whole thing, sir.
My lord, I am not taking much time. Then at para 9, they also again meeting has been held in 78.
All right.
That is also they have mentioned. At para 10 is most important. Para 10 is that in reply to averment in paragraph 4.6 of the writ application, it is humbly submitted that Honorable High Court in the judgment dated 5/11/1979 passed in Narayana Behera case pronounced that Keuto Koibarto community have to be treated as synonymous name of Diwar. The state government on the advice of law department had filed a special leave petition, filed SLP number 1980 before the Honorable Supreme Court India challenging the above judgment the Honorable High Court. But this said SLP was dismissed by the Honorable Apex Court. This is what against the petitioner. That is the maximum case. They have challenged that order. That order, there is no direction of pronouncing Dhibaro, Keuto, Koibarto. There is a direction given in the case of Narayana Behera. Since you have issued a certificate, he should continue as scheduled caste as you have issued certificate as Diwar, not Dhibaro. They have not stated that if Dhibaro, Keuto, Koibarto will be issued certificate. That at para 11. That in reply to the averments made in paragraph 4.7 of the writ application, it is humbly stated that the state government had recommended to Government of India several times for deletion of the community of Diwar from scheduled caste list of Odisha. Lokur Committee 1965 and the JPC on 1965 bill have also recommended for deletion of the community Diwar from SC list of Odisha on the ground that there was no genuine Diwar community in Odisha. And also observed that the people of fisherman community who are not untouchables, this is a state government view, they are not untouchables, are returning themselves as Diwar. Besides, as per the instruction of the state government, the erstwhile Tribal Research Bureau, now Scheduled Caste Tribe Research and Training Institute, has conducted the broad-based ethnic status study on Diwar community in 1962 and 79 and furnished its report to the state government. From the above studies, it reveals that there is no fishing community called as Diwar in Odisha. Diwar is a community having a number of traditional occupations, begging, playing musical instrument, singing, dancing, etc. They are nomadic people. They don't have any house. They are shifting one state to another. And they are found in Madhya Pradesh. All these aspects are placed before the State Scheduled Caste Welfare Advisory Board in its meeting dated 16/11/78 and 27/8/1991. The board have recommended for exclusion of the community from the scheduled caste list of Odisha. Accordingly, the state government furnished the proposal to Government of India for a deletion of Diwar, followed by several reminders. They have not only proposed, they themselves in their counter affidavit have admitted they have issued several reminders. There in para 12, it is humbly submitted that the Registrar General of India had supported the proposal of the state government for exclusion of Diwar community from the scheduled caste list from Odisha on several occasions, including 79, 2001, 2012, as indicated in the above para of the writ petition. To my reply, they have admitted that yes, it has been proposed. That in reply to the amendments made in paragraph 4.10 of the writ application, it is humbly submitted that Government of India in past have turned down the proposal for inclusion of Diwar, Keuto, Kaibarto as synonymous of Diwar. But in order to comply the direction of the Honorable High Court of Orissa passed in OJC number so and so, Keuto, Kaibarto,
You are
Diwar
repeating
community.
yourself, sir. This is all you've argued already.
No, this is what they have taken.
Correct, sir. They're supporting your stand. This is what you've argued. All right, sir. All right. Move on to your next point now.
The point is that there is no dispute that this amendment is made on the basis of the judgment in the case of Narayan Behera and others. Now it is to be seen whether this Narayan Behera judgment, any such direction has been given or that judgment is valid on the date of amendment. Two aspects is to be seen. Whether any direction has been in Government of Orissa or Government of India to include this community as in the list of.
Let us assume no such direction.
No, there is no direction.
Correct. We agree with you. There's no such direction.
My lord. Thereafter, this I have already cited that Supreme Court in the case of Sirish Kumar Chaudhary, which they have submitted, has also read.
You've already read that paragraph, sir.
My lord. That I am.
Don't need to repeat it. Please don't repeat any argument.
I'm not repeating. I'm just overlooking that. Thereafter, in the case of Director of Tribal Government of FP, Lebati Giri and another, 1995 Air 1506. This Honorable Supreme Court in the year 1995, this is a two-bench judgment. The kinds boy then. Judgment is judgment whatever. Court judgment whatever. In page 11, Director and TN. Madam, I'm sorry. At page 11, para 8. While reiterating the above guidelines to be workable principle, it is high time that Government of India would have the matter examined in great detail and bring about a uniform legislation with the necessary guidelines and rules prescribe the penal consequence on persons who flout the constitution and come to the benefits reserved for the real tribal, etc. So that the menacing of fabricating the false records and to advantage by plain spurious persons would be prevented, lest they would be defeat the constitutional objective of rendering socio-economic justice emphasized under Article 46 in the preamble of the Constitution under Article 14, 15, 16, 38 and 39. Thereafter at para 9, by the orders of the High Court, the respondent have already completed his engineering course. Though he played a part on the Constitution depriving the real tribunal of the benefit of the education as an engineer, he was a minor at that relevant time. Nothing can be done except declaring that he is not a tribe and that he is not entitled to any employment or any other advantage on the basis of his false status of the scheduled tribe, namely Konda Kapu. His father did not appear before the director and he is not before this court to direct the government to lay prosecution. Accordingly, appeal is allowed with cost of rupees 25,000 to defray this man. This issue is that a fraud has been committed in the name of the judgment of Narayan Behera, where is no such direction has been given, nor that judgment is valid on the set. That is what I am citing. Thereafter, in the case of S. Sogurudas versus Zonal Manager FCI. At page 3 and 4, para 8. This is Supreme Court judgment, 1996 year, prior to the amendment. Para 8. Courts therefore have no power except to give effect to the notification issued by the president. It is settled law that court would look into the public notification under section 341 or 342(1) for a limited purpose. It's an article. It should have been article. The notification issued by the president and the act of the parliament under scheduled caste and scheduled tribe orders 1976 and schedules appended thereto can be looked into for the purpose to find out whether caste, race, or tribe are parts or groups within the race, caste, tribe shall be scheduled caste for the purpose of the constitution. Under the Amendment Act, again, the parliament has included or excluded from the schedules appended to the constitution which are now conclusive. Schedule 1 relates to the scheduled caste and Schedule 2 relates to scheduled tribe. The Christian is not a scheduled caste under the notification issued by the president in view of the admitted position that the petitioner was born in Christian, his parents were also converted prior to his birth, no longer remained to Adi Dravido, a scheduled caste for the purpose of Tirunelveli district as notified by the president. The crux of the issue is the court cannot give. The thrust of the issue is that court cannot give direction to anything. That is Supreme Court has told.
Right.
Then in the case of Pankaj Kumar Saha versus Subdivisional Officer Islampur and others. This is a division bench judgment of the Honorable Supreme Court, wherein at page 2, para 5.
Right, sir. We'll look into all this, sir.
8th line. And para 6. The court is devoid of power to include in or exclude any substitute and plus synonymous.
All right, that's a consistent view.
That in the full bench judgment of the Honorable Supreme Court of India in the case of Nityan Sharma, wherein year 1996, Supreme Court 2306. This is High Court reference. This is a reference at page 2310, para 14.
Right.
It is for the parliament to amend the law.
Right.
The schedule and they include or exclude from the schedule of a tribe or a community or part group within the tribe or a tribal community for the state. District or region and its declaration is conclusive. The court has no power to declare synonymous as equivalent to the tribes specified in the order in substitute of the scheduled caste or scheduled tribe, etc. That is the whole case. That is the court does not have power, and they have made the amendment on the basis of
both of you are agreed on this one point.
Minor. Then there is at 19 also same thing has been repeated. I don't want to take much time of the Honorable Court.
Right.
And in the case of Prabhudev Mallikarjun versus Ramachandra Virappa and another.
Mr. Sethi, I suppose you're realizing they cited only 2 judgments for this proposition. You have cited judgments for the same proposition. That court should not interfere.
That is my case they have cited.
Correct. That is also their contention. That's why I'm saying on this one contention, everybody is in agreement.
That is whole case.
Correct.
That is why my case is that.
Correct.
My point is that court cannot give direction. And they have made amendment on the basis.
That's what I was telling my colleague also. The court should not do anything.
Court has the power to see whether the amendment made in the parliament is intravirus or ultravirus.
Correct.
That is there. But court cannot give a certificate that this.
That's right. Everybody is telling us you better keep quiet.
My lord. That I am coming.
Correct.
It is delegate. It is all that thing. Nine. Kind of story. It's a full bench judgment of the Honorable Supreme Court of India.
Right.
Page 2, same issue.
Correct.
Same issue. Thereafter, our Odisha High Court judgment.
Right.
This is in the case of Rupa Sindhu Sahu versus Hindustan Aeronautics Limited.
Right.
This judgment has been referred it's passed on 1998 prior to amendment. That is what relevant is at
right.
That is at page 4 para 7. There they have relayed the judgment of the Narayana Behera and others of Odisha High Court. That is what this community is to be made. as included in the scheduled caste. The Honorable Odisha High Court, in their judgment at page 11,
So they referred to same Nityananda Sharma and also.
page 11, para 25. The decision of division bench of this court is generally acceptable to another division bench unless it differs or is referred to a larger bench.
Correct.
But if there is a Supreme Court decision on the specific point and sets at the rest, the issues involved, the ratio of the decisions of other benches loses its importance. Therefore, they did not
Follow Narayana Behra.
Narayana Behra. This is why they have passed there.
Correct.
And so para 26, all the same thing has been mentioned, how this Nityananda Sharma judgment, they have reiterated, the Honorable High Court has reiterated the decision of the Honorable Supreme Court in the case of Nityananda Sharma, as well as others, and dismissed the petition that this community cannot be included. That is prior to amendment in the name of Narayana Behra.
Community is Nayari, the Nayari community.
They are claiming, they are claiming
correct.
We are
so they did not agree to that.
We are synonymous to Divara, therefore we should also be included.
Correct.
Because they are telling that their tribe and we are having marriage or relations for which we should be also included. They are telling that no, we cannot do, and that judgment is no more valid.
All right.
This is prior to the amendment.
Right.
My lord. And the state of Maharashtra versus Milling, they have reported in their maintainability issue. I am also relying the state judgment.
Very good, very good.
That is why I am telling that whether at all it is permissible to hold any inquiry, let any evidence to
decide. No need to read, sir. This is all the same thing. Again.
This is the same thing.
Right.
They have relied, and at para 11, running page 17, 7th line, that is mentioned that Parliament is alone competent. This is a full bench judgment.
Correct.
And at page 16 and 17, also same thing. It is related Nitin Sharma, referring certain English decisions.
Right.
ELR 212. I don't know what is this. And subsequently, this is the case. Whole case is
correct.
Thereafter, and all these cases, only one thing emerged, that court does not have the power to direct any task to be included and any inquiry to be made.
Correct.
Court cannot interfere. But the constitutional court has the power to see any act of parliament or act of legislature is within virus or ultra virus. Here the question, main issue thrust is that amendment is not done in accordance with the procedure laid down in the year 1999. There is no dispute to that. Amendment is being made and inclusion has been made on the basis of the judgment of the Honorable High Court, which does not exist, for which they at least include.
So why are you people worried about that? You also belong to the scheduled caste, right?
I am belong to.
So why do you want another member to be out?
Because they are not scheduled caste.
No, why,
they are not untouchable.
Why should you worry?
They are not untouchable.
Why are you worried? Why are you worried?
Worried because in between this there is a fisherman community, another is Keuta, Koibarta, and Dhibor. London prison judge might have been.
You do not belong to any community.
Which community?
That's why you're asking you why. What is your interest in getting these people out?
My interest is that this status of scheduled caste is given to the genuine untouchable person. These persons are not scheduled caste. They are not untouchable. They cannot claim such thing. And claiming that they are affecting the rights and privileges of others, which has been given by the constitutional mandate, which has been part of the judgment.
You're saying your share of whatever is the
genuine scheduled caste are suffering, and particularly Koibata community, which is included. This Honorable Prison Judge is made to be aware that this is a priestly class. They are worshipping Lord Shiva in Odisha throughout. That is called Chudakuta Keuto. English, what is that? Exactly, I cannot say. But this Koibata class is included, and they are taking highest benefit of this. This Dhibara, the Keuto, they are not taking that much of benefit. This Koibata community is the problem for the whole thing. They are taking more than 50% of the entire reservation laid down for the scheduled caste people, having a percentage of population among themselves 2% or less. Suppose scheduled caste percentage is 50%. They might be having percentage of population 1%. They are taking posts of 50% more than that, and they are not actually untouchable. for which they are nowhere sitting with others.
All right,
They are telling the
let's
truth.
hear the other side now.
Mine.
All right.
The entire argument which I should have done, my learned friend has done, that
Right.
is so far the power of the court to interpret.
Correct.
Let's kindly look to the prayer portion.
Right.
Which, the writ application, what is the prayer? To declare entry 24 of the amendment to the Constitution, Schedule Caste Order 1950, and the Constitution, Schedule Caste Order, Second Amendment Act 2002, ultra vires, Article 341 of the Constitution of India. Then two, to direct the opposite party to revoke all the Schedule Caste certificates issued in favor of person belonging to Keuta, Kaivarta, Dhibara community in the state of Orissa. Then three, to direct the opposite party to remove the person in service who are belonging to Keuta, Kaivarta, and Dhibara community and employed basing on reservation. Now, in the date chart, Your Lordship, I don't want to place it in details. A judgment in Naran Vera's case was delivered on 5/11/79. That was challenged before the Supreme Court. That was appealed on 24/9/1980. Then the other consequential date, the state has made the recommendation and all this, and a bill was prepared. Now it is an act of parliament. Now, Your Lordship, kindly just but to that judgment, Your Lordship, look, only one judgment I saw, nothing, because a law is, had my learned friend said that is well settled, and all the judgments said the court, what is the court power in so far as these matters are concerned. You also look to that judgment. Para, I have given to a copy of the judgment.
2018.
Memo of citation.
2018 judgment.
Yes, sir. Sir, because there is some the
Para 32, 36.
If Your Lordship have the SCC, then I can place from the SCC also.
Yeah. It's there with us. It is
Memo of citation is
Deep Singh, correct.
Yes, Your Lordship, kindly look to para 19.
Right.
I've given the monopatras, of course.
Right.
That some paragraph is varying from the SCCs.
Right.
The presidential order, para 19, presidential order enumerates list of caste, race, tribes recognized as scheduled caste, scheduled tribe cannot be challenged or agitated in a court of law except for the count to held in Nagarajan versus so and so. If you illustration was given, let us skip over. Kindly come to para 20. Whenever state reorganization has taken place in the past, Parliament had exercised its power under Article 341(2) and 342(2) and provide for specific caste tribes that were entitled to be recognized as scheduled castes and scheduled tribes in relation to recognized state union territory. The scheme of the Constitution, scheduled caste, scheduled tribes orders makes clear that Parliament intention was to extend the benefit of reservation in relation to the state union territories only to castes and tribes as mentioned in the presidential order, para 21. The order of 1950 was amended by the Constitution, scheduled caste and scheduled tribe order by the Amendment Act 1956. Another amending act was enacted by Parliament in 1976. Earlier order had been made for first time in relation to certain territories such as Constitution and amendments of the Scheduled Tribes Order 1950. Further
Anyway,
amendment.
they're all listing out all the amendments.
That straightway come to paragraph 29. Para 29, which my learned friend had placed, various judgment has been referred to. Sorry, page 30, para 32. Para 32, page 17 of my
upshot of the aforesaid.
Yes, sir. The upshot of the aforesaid discussion would lead us to conclusion that the presidential order issued on Article 341 in regard to scheduled caste and order Article 342 in regard to scheduled tribe cannot be varied or altered by any authority, including the court. It is the Parliament alone which has been vested with the power to so act, that too by laws made. Scheduled caste and scheduled tribe, thus specified in the relation to a state or union territory, does not carry the same status in another state or union territory. Any expansion, deletion of the list of scheduled caste, scheduled tribes by any authority except Parliament would be against the constitutional mandate under Article 342 and 342 of the Constitution. That's all. I've given a date chart for your Lordship's convenience.
And the opposite pattern number 7, I will take your Lordship only to the provision 341(2). 341(2) provides, it is the one provides, the President may, after consultation with the Governor, by public notification, specify the caste, race, tribes, or parts thereof, groups within the caste, race, or tribes, which shall be for the purpose of the Constitution be deemed to be scheduled caste in relation to the state. Then 2, Parliament may, by law, include or exclude from the list of scheduled castes specified in the notification issued under clause 1 any caste, race or tribe or part of or group within any caste, race or tribe, but save as aforesaid, a notification issued under the said clause shall not be varied by any subsequent notifications. That gives the empowers only to the parliament to change, to cause any change in that is the provision of the constitution. My learned friend, Mr. Rautray has submitted before your lordship. I adopt that argument. I may specify. My learned friend has cited 1994 1 ACC, page 359. The relevant paragraph is 17 and 18. And my learned friend has cited 1990 Supreme Court Supplementary 1 ACC, page 220, paragraph 16 and 20.
Sirish Kumar Chaudhary.
Sirish Kumar Chaudhary, that is paragraph 16 and 20. And in 1810 ACC, my learned friend has already cited. And 2001 ACC, page 4, paragraph 15 and 28, which is reflected in your lordship's order, dated 29/6/2022. The relevant paragraph is 15 and 18. In addition to that, I may bring your lordship to only one judgment, that is 2049 ACC, page 236, to the same effect. Paragraph 13. I am not repeating those judgments. It is important to bear in mind that it is by virtue of the notification of the President under Article 341(1) that scheduled caste come into being. The members of the scheduled caste are drawn from the caste, race and tribes. They attain a new status by virtue of presidential order. Clause 2 of Article 341 empowers Parliament alone by law to include or exclude from the list of the scheduled caste specified in the notification issued under Clause 1 by the President. By no executive power, amendment, modification, alteration or variance in the presidential order is permissible. It is not open to the executive to do anything directly or indirectly which may lead to any change in the presidential order. Once the presidential order has been issued under Article 341(1) or 342(1), any amendment in the presidential order can only be made by Parliament by law as provided in Article 341(2) or 342(2), as the case may be, and not in any other manner. This is the law. My lord, in addition to that, my learned friend has taken to your lordship to some documents which shows these castes were not there prior to their inclusion. In 1936, I have annexed A/7.
You don't have to get into that.
That is not relevant. There is series of documents are there. These Hivar, Keuta and Koivarta, they were in the scheduled caste list in the state of Odisha in 1936, in 1949. I have annexed those documents as annexure A/7, B/7 and C/7 to my affidavit. File that is at page 401 to onwards.
One line, that's a kind permission. My learned friend, entire argument, what I understood, not so far the question of maintainability is concerned, Lordship asked that question in the last order. He has not answered that. Rather, he relied upon those judgments. But only question I can give, the entire argument is that Narayan Behra judgment is wrong. If Narayan Behra judgment is wrong, that has been upheld by the Supreme Court. Now he sought to review that judgment. Is it permissible? That is the whole thing.
Yes.
So, Manoj, may kindly see page 32. The Parliament take notes of the judgment of this court. The page 501, the Supreme Court order wherein Narayan Behra was challenged before the Supreme Court and it was dismissed. So, after now almost 42 years, the entire thing is being sought to be revisited in this manner. Now, they have relied on the counters of the state and the union. There, my lords, I would rely on Mohinder Singh Gill, my lords, where the Supreme Court says that you basically have to see the order itself.
Yeah. No, but this is in a different context.
Yes. So here the order itself, the order, my lords, at page 32, it says that they have taken.
No, this is giving reasons contrary. See, So Mahendra Singh Gill, what they meant was, suppose it's an unreasoned order. You can't supply the reasons. Here, this is to the contrary. They've carried out an amendment. Now what they're saying is contrary to that. They're saying we should not have done it. So he's therefore relying on it. He says they themselves say they should not have done what they have done.
But then that would...
It's contrary. It's the converse case of Mahendra Singh Gill.
So what the state couldn't achieve in that SLP, they are trying to get it done in
We don't
this
know.
PI.
We don't know. That's the correspondence.
No, but that's what the state SLP is on record. State's SLP, where
Anyway, yes,
that is there. So what the state couldn't achieve in its SLP, they want to get it done in this, which according to me is not permissible. At flag 12, I have given a short note.
You are for the central government.
I am for the central government.
Oh, sorry.
I am for the central government, my lord. What my learned friend appearing for the petition did that in the counter filed by us, we have admitted that we have committed mistakes. That's not correct. In actually, as a matter of fact, I being a government counsel, my duty is to support the law. My duty is to support the law. Annexure 1, annexure the first annexure filed in this along with
But
the
at
counter.
the same time, you will not be allowed to argue contrary to your counter affidavit.
Yes, madam. I cannot. I cannot. Counter affidavit was filed way back in 2013.
Whenever. Right.
My lord, 2002 amendment entry number 24 is the community which was included in amendment 2002. That prior to that, a modality came. As per the modality, state government is to give some proposal for inclusion or exclusion. Thereafter, the role of central government comes. State government proposed. Central government, after making some investigation, agreed to that proposal. As per the modality, after both the state and central government agree, it will go to the National Commission. National Commission also it went.
They also agreed.
Yes, my lord. They also agreed. Thereafter, no step has been taken.
Why have you not taken any step?
That is a relevant question your lordship asked me. I am not in a position to answer to that because the counter was filed.
That's the whole point. That's the whole point. That's why Mr. Sethi is here.
I understand that. I understand that.
All right. What's the state government? You also agree wholeheartedly with the petitioner. Obviously.
We had filed an additional affidavit in 2019, my lords.
Yes.
Which my lords have to be read with, my lords, with our affidavit, which was filed prior to that. In para 17 of the previous affidavit.
Yes.
We have said that I may read para 17 first of the first affidavit that we have. That the above said broad-based study report of SC/ST RTI is now under active consideration of government. After due examination, the matter will be placed before the Scheduled Caste Welfare Advisory Board for its consideration and recommendation. That is where we leave, because prior to that, whatever recommendations had been sent prior to that had been listed out. Thereafter, my lords, we filed this additional affidavit in 2019. Where, my lords, at running page 412, my lords.
Yes.
Para 5.
Yes.
That in addition to the averments made in para 17 of the counter affidavit filed on so and so, it is humbly submitted that the Scheduled Caste Welfare Advisory Board of the state government meeting was held on 5/6/2015. The SC Advisory Board decided to send the matter to Government of India so and so for continuance of Keuta, Koiberta and Dibar as synonym of.
You seem to change your mind now.
Please, minutes. In SC list of Odisha at.
So vacillating. Right. So you took one stand earlier, now you're trying to take another stand.
Please. And that, my lords, has been sent to the Government of India. Because my lords may see annexure B4, where we have said that why this stand was taken.
Right.
So second para. Subsequent to forwarding of the views of SC/ST RTI with the above mentioned letter to your office, the matter came to notice of the government Commissioner cum director so-and-so was called for discussion. And on the basis of the views that the communities of Devar, Keuta, Kaivarta and Dibar do not suffer from untouchability. During discussion, it clearly transpired that the view of SC/ST RTI was based on the non-prevalence of practice of untouchability currently in the present day scenario or context. It was not based on any data or evidence indicating non-prevalence of traditional practice of untouchability in historical context suffered by the above communities. For any caste to qualify for being included in the SC/ST list, SC list as per the existing criteria of Ministry of Social Justice and Empowerment, a caste must suffer from extreme social, education and economic backwardness arising out of the traditional practice of untouchability.
Okay.
So, Milord, that is, Milord, the basis on which this flip-flop has happened.
One affidavit I have given, if you also, I could not able to get it from the note. When the state government has moved and these castes must be included, that is there. But I have given a copy of the affidavit, also you can look to it. This is the list. The state has moved in 87.
All right.
I filed it by affidavit. And this Keuta Kaivarta is there in the second page also, the list of them to be included.
Kaivartas. All right.
Yes, sir.
Page 449 of the brief. My lord, kindly have a glance to page 449 of the brief. Now the state government said something, but their letter speaks the otherwise. Page 448, this is a letter from the commissioner cum secretary to the government, to the director. And I'm reading out the relevant only small.
What's the date? What's the date of the letter?
Letter date is 1/6/2016.
No, they've changed that, sir. This letter actually, they've changed that view from that. They've changed that view. They said the earlier view is inadvertence. This is what he read just now.
Yes.
The earlier view they say was inadvertent. Yes.
That 87 letter is the letter on the
Right.
My lord, so far the SL.
Lots of kind permission have been called.
My lord, none of them and all of them have agreed, rather none of them, all of them agreed that this has not been done in accordance with modality. This is done on the basis of Narayan Bhera judgment, which I have challenged, and the virus of this said action is within the four corner of this Honorable High Court. This High Court can examine whether the due procedure have been followed in inclusion or exclusion. And so far as SLP dismissed is concerned, SLP dismissed does not mean that law is settled. Rather,
Kuni Ahmed.
Minor.
There's a judgment called Kuni Ahmed.
Minor. Minor. Subsequently, all the judgments of the Supreme Court says otherwise. So far as the PIL is concerned, it is for the general public interest, which the real scheduled caste is going to be affected by this fake scheduled caste because they have not been included in accordance with the due procedure. So far as they are citing certain things that state government has proposed this or that, we have no objection if state government proposed RGI approved, in National Commission for Scheduled Caste approved, then they have amended, we have nothing to say. Only thing is that they have done in clear violation to the modalities prescribed by them. And on the basis of the judgment, we does not have any course on the said date. The Honorable High Court in the case of Krupasun Sahu also overruled this. This is what matters.
Orders reserved.
Kuni Ahmed allows review. This is fresh PI. Fresh PI, those parties are not there. They're not joined or it's hit by non-joined.
Yes.
Supplementary list item number 82. 82, sir.
My lord, I am filing
note.
Filing the note, yes, my lord. I'm giving the copy.
My lord, in this PIL, to espouse the cause of the ST/SC students, in whose case inordinate delay has been committed in payment of, in disbursement of stipend they are entitled to. For 1 year, in a school that is Government Girls High School, Aska in Ganjam district, no ST/SC girl was paid stipend for whole year. Then it is admitted by the opposite parties, my lord. A girl of class 7 committed suicide for the simple reason that her parents were not able to pay her 10 rupees to buy notebooks. And this thing has been confirmed by the police report also, my lord. They filed an affidavit
by the granted 1 lakh compensation. They have paid 1 lakh to the parents.
1 lakh ex gratia, yes.
Right.
But this is grossly adequate in view of the irreparable loss suffered by the family.
All right. Who's appearing for the state?
We filed this affidavit. That is, police report says affidavit.
You admitted to the negligence.
Yes, my lord. That the mother scolded her, and that is why she's set herself ablaze, my lord.
Yes.
And we've also filed an affidavit at the special officer, Commander Secretary to the Government of Orissa, my lord.
What's the current position on disbursal of stipends? What is the
My lord,
current
I'll
position?
take instruction. We don't have the current position, my lord. I'll take instruction because this affidavit we had filed.
The PIL makes a of the inordinate delay in by the state government in disbursing stipends payable to students belonging to the scheduled castes and scheduled tribes in the state. Full stop. The present petition arises out of an unfortunate death by suicide of a class 7 student belonging to the SC, studying in Ganjam district, in a government school in Ganjam district, on account of a parent's inability to pay rupees 10 for buying notebooks and pencil. Full stop. It appears that the state government has already paid, after conducting the inquiry, the state government has paid a sum of 1 lakh out of the Chief Minister's Relief Fund as ex gratia. Paragraph, while the petition has been filed for compensation to the parents of the deceased young girl, the court would like the state government to place an affidavit. What corrective steps have been taken to ensure prompt disbursal of stipends to students belonging to SC and ST throughout the state? Full stop. A detailed affidavit in this regard be filed with the state government before the next date. List on 15th December.
15th? Item number 83.
15th November or October?
December. Item 83. I have
This writ appeal is filed against the judgment of the Honorable Single Judge by the Annexure 10, my lord, where the Honorable Single Judge has held that the petitioner is not a resident of the service area of Anganwadi Center, and he is not entitled to get benefit. And as he has secured highest mark, he is debarred from getting the job. My lord, the fact is like this. My lord, kindly annexure, kindly see page 20, annexure 1, the advertisement. The center is at page 20, my lord. That is Odia vernacular. The center is at Jagannathapur Panchayat, Baravati, and the place of Kumar Sai, Baravati. And my residence are next, annexure 3, my lord, my residence certificate. That is page 22, my lord. This is certified that Madhusmita Das, wife of Abhimanyu Behera, is a resident of a village Jagannathpur, Pada Baravati, Sai, of the district of Puri in the Orissa, and her family ordinarily resides in the town of Jagannathpur, Pada Baravati, Sai. Then, my lord, the mark sheet I have secured, Annex 4, that is the mark sheet. I have secured 331 marks. While the respondent who has given appointment, he has secured 321 marks, Annex 5, my lord. He has secured less mark
than page 40, sir.
My lord.
Kindly read page 40, sir.
My lord. The petitioner has submitted the application form along with the residential certificate in order to verify the nativity of the petitioner. The selection committee has directed the RI to conduct an inquiry. RI has conducted an inquiry and found that the petitioner is residing in Haripur and not in Jagannathpur, where the Anganwadi center is situated. Accordingly, the candidature of the petitioner has not been considered. Being aggrieved with this, the petitioner has raised an objection by way of preferring an appeal before the ADM, who, after hearing both the parties and in order to get the matter verified, has directed the RI to conduct an inquiry. Thereafter, the inquiry report has submitted, wherein finding has been given that petitioner is not residing in the area where the center is situated, which is the precedent condition for consideration of the candidature as per the guideline dated 2/5/2007.
What do you say?
My lord, that is Annex 2, my lord, the joint inquiry, that is page 36, my lord, kindly glance.
Yes.
The joint inquiry of CDPO and the RI.
Yes.
That is 26/9/2015.
Yes.
I have conducted inquiry on 26/9/2015 at village Jagannathpur, Pada Baravati Sai, PS Pipili, district Puri, at which place the petitioner Madhusmita Das is self-residing with her husband. The Tahsildar Pipili has been duly intimated through official correspondence made on 2013 to conduct a joint inquiry. On behalf of RI Pipili, Pipili is present today at the particular spot and accompanied me to conduct inquiry. We both are assented on verification of case records, a villager statement, and marriage documents that Madhusmita Das, the appellant, self got married to Abhimanyu Behera since last 11 years and presently residing with her husband at her in-laws residence, local at village Jagannathpur, Pada Baravati Sai. This is the joint inquiry report. And my residence certificate is that is the center where is the Anganwadi center is situated. That is got on RTA report, RTA Act, this report.
What is this at page 31? This is your appeal filed, correct?
My lord. In appeal, as the appeal was dismissed, I preferred read petition.
No. In the appeal, it's been found that you are a resident of Haripur.
No. I am not a resident. My resident certificate is Jagannathpur Baravati. Inquiry RI report is Jagannathpur Baravati. And joint inquiry is
the report that he's relied on. If that is the report that has been placed before the Honorable Single Judge and the ADM or not, I'll call for the records and.
All right, the record of the entire inquiry and the records of the ADM be placed before the court of the next date. List on 14 December.
Item 84.
May I please, your lords? Here the fact of the case is like this below. The petitioner, respondent 3 years here, was appointed as a librarian in the post of librarian on 30/12/86. Since he had no appropriate qualification of bachelor degree in library science, a condition was put in his appointment order requiring him to acquire the appropriate qualification within a period of 1 year. He joined his service, but left the service, abandoned his service, and after 5 years, he came and requested for join. His service was terminated. He approached the Learned Tribunal, Education Tribunal, Annexure 1, Your Lordship may see. The judgment of the order and judgment of the relevant portion, I may, Lordship may come to page 18. Page 18, from bottom 4th line. I further hold that the case is barred by limitation for having been filed after stipulated period of limitation of the month.
Passover, on where would risk a das Passover?
Who are you appearing for, sir?
My lord.
Who is he appearing for?
Opinion number 3, my lord.
All right, Passover.
Supplementary item 85.
Let me please, Lordship. Dear Lordship, may kindly turn to page 27, annexure 9. Let there is the Wesco Authority, utility minute. They communicated the petitioner that because of the pendency of this writ petition, 2211 of 2013, so the admitted dues could not be returned. But now that this WOP, this writ petition, 221113 has been dismissed, that connected record has come. As infractuous. So in view of that, the outstanding dues may be cleared by the opposite party. But the other connected matter has come. So that has been dismissed. It was filed by Wesco. They said that because of the pendency of this case, we are not able to clear the dues.
All right.
Now that the other petition.
Why is it come to the DB? Why is it before a division bench, sir?
Maybe it was coming earlier, therefore I don't know why it is. The other matter is 2211 of 2013. That was dismissed by your Lordship, 16/8/2022. The other connected matter is there. 2211 of 2013.
Why?
That was dismissed by your Lordship on 16/8/2022. That is the other connected matter. So therefore, the communication of the Wesco was that because of the pendency of that was filed by the Wesco mirror. So division bench, I think it is the all those earlier orders I see it was listed before your Lordship.
All right. From the order dated 24th July 2017, it is seen that the security amount which was to be refunded to the petitioner was withheld on the plea that civil 2211 of 2013 filed by Wesco is still pending in this court. Full stop. Paragraph. It is seen now that writ petition civil 2211 of 2013 now stands disposed of as having become infructuous by an order dated
16/8/2022. 16/8/2022.
It's shown in the list. How can it not be there? So you have the order in this.
Yes, Milord, I'm reading, Milord. Learned counsel for the petitioner states that the matter has been rendered infructuous. Para 2, the writ petition is dismissed as infructuous. The interim order passed earlier is vacated. Milord,
What's the date of this order, sir?
By Milord, order dated 16/8/2022. I am having Milord holding the copy, Milord. It is downloaded from the website.
By an order dated 16 August 2020. In that view of the matter, now there should be no impediment in the refund amount being released to the petitioner. Why is this not scanned and put in this?
Order number 4, Milord. That is by my Lord, Your Lordship and Justice, same bench, Milord.
Right. We got it now. In that view of the matter, the writ petition is disposed of, the direction to Wesco. And the present entity, which is Tata, the present
Tata
entity must be
Power
something else.
Limited, Milord. Tata TP CUD. Tata Power Western Utility Division, I think, Milord. TP Tata Power Western
Orissa Distribution Limited, I think.
Yes. TPCOD is central. Milord, I'll furnish that. I'll furnish that.
To refund the amount to the petitioner within a period of 8 weeks from today. The writ petition is accordingly disposed of.
Milord, that name is, Milord, one second. That is Wesco Utility Department of Commerce. No, that name I will supplement. That name I will supplement.
Yes.
I am providing it. Oblige me.
Item 86.
May I please? Pursuant to Lordship. Order dated 26/8, Milord. The case has been posted. 26/8/2022.
Now, this has to be hard on merits.
Yes, yes.
May kindly straightway turn to page 96, annexure 5. And may only state the few facts. Well, the writ petition was filed, and on the first date of admission, the writ petition was disposed of. So I have annexed all these documents in the writ appeal. So you'll also may kind down to page 96 that is annexure 5. Well, this is the rule 2020, which came into force on 17/2/2020. Now, my lord, may kind down to next document that is at page 114, annexure 6, page 114.
Yes.
And this is letter number 110008, dated 10/9/2020. My lord, 2-3, that is the respondent. Subject, furnishing of information with supporting documents for consideration of pending array application as per Rule 6, 9 and 10 of OCS Array Rules 2020. You will also make kindly mark. The rule is, we have mentioned that each application will be considered in accordance with 2020 rules. In inviting,
So that's the whole problem, sir.
Yes.
Because of the Supreme Court in Malayan and the Sethi,
yes,
this has to be considered on the basis of the rule that was prevalent when he applied.
No, you will also make kindly see that judgment.
There's a reference in it to the larger bench.
Yes.
So we've adjourned several matters.
Yes, I am
awaiting the larger bench of the Supreme Court.
Similar order I am passing.
But, my lord, so far as this case is concerned, my lord, the Honorable Supreme Court passed orders, my lord.
That's right. It has come back, sir. It has come back. Now we'll have to again deal with it.
I bow down to Lordship's observation. But
We have already recalled the earlier order. We have now placed it before the bench for a fresh hearing.
My lord. But the Honorable Supreme Court observed, my lord, that it is to be taken note of in terms of Malaya City. That was the observation. My lord. If you also look at that order.
No, that is true. But sir, the problem is there is a reference to the larger bench in SBI versus Shiv Shankar Tiwari.
My lord, that is there, my lord. That you Miss Sangat, Dipanjali's case.
As far as recalling is concerned, we've done it in view of Malaysia Nanda Sethi. There's no difficulty. But as far as the main writ appeal is concerned, we've been awaiting the judgment of the larger bench because of the reference made in SBI.
Well, with great respect to Lordship's Manor, Judge, I'll read that observation passed in the particular case. If Lordship kindly permit me.
That was in respect of review application is concerned.
Correct.
No. I'll just read that paragraph. We request the High Court to consider the subsequent decision against the relied upon judgment.
Correct.
Appropriate order considering the subsequent judgment and order passed in civil appeal number 4103 that is Malayalam City.
Correct. So we've done that, sir, and therefore recalled our order. The review petition was allowed, and the writ appeal has now been placed before the roster bench. We've already done that, sir.
I leave it to Lordship to consider in terms of Malayalam in this case.
No, that's right, sir. We did consider that, and that's how that order was passed.
That now government is considering the city case in terms of that judgment.
You see, same order, I think. We'll pass the question whether the application under the Rehabilitation Assistance Scheme must be considered in light of the rules prevalent on the date of the death of the government employee or the date of the examination of the application is pending before a larger bench of the Supreme Court with a reference having been made in SBI versus Shiv Shankar Tiwari 2019 5 SEC 600. In that view of the matter, awaiting the judgment of the larger bench of the Supreme Court, the present appeal is adjourned sine die with permission to the parties to mention it listing after the decision of the Supreme Court.
Interim order to continue.
Interim order to continue.
Well, we are not finding any contempt, my lord.
Or in that case, there's no interim order. It is pointed out by counsel for the respondent that no application for contempt has been filed. That view of the matter,
they can.
But there's already a stay, sir.
Yes.
So let it continue. The interim order to continue. All right.
Supplementary list item 87.
Well, it's item 87, seeking some time to file that map. This is that Shamshan matter where there's a panchayat of instructed on a land and compensatory land has been earmarked. But my lords had directed for a rough sketch map on the last.
Counsel for the state needs some more time to file a rough sketch map as directed on 17th August 2022. That is request list on 7th December.
Item 88.
May it please, my lord. Lord, this is that case, my lord, where royalty was demanded, irrespective of fact that no claim was made before the interim resolution professional, nor before the adjudicating authority, or before the appellate tribunal, my lord, while approving the resolution plan, my lord. Resolution plan specifically says that
the counter not filed, sir. Counter has to be filed.
Millards 88 Millards, the counter has to be filed. Millards, so far as Millards 88 and 89, both Millards deal with a similar question of law. Which
have you filed counter, sir?
Millards 88 Millards, I haven't filed counter. I will file counter.
89 you have filed.
89 Millards, we have filed counter. But since
but we have not. With counter by OPs, rejoinder not received.
Yes,
in 88, you say counter be filed within 8 weeks, rejoinder for the next date. In 89, you say rejoinder be filed for the next date. Is there an interim order?
Yes, my lord. Both the cases, interim order is there.
Order to continue.
In both the cases, my lord.
List on 25th January.
Supplementary list item number 90.
My lord.
There's a note.
90, your lordship's last occasion.
There's a statute, new statute now.
In compliance of the last order, in the meanwhile, we have amended the rules and the format of agreement for sale has already been notified. I think everybody must be satisfied with the development.
That was not an issue. That agreement for sales has been notified. We are on the Apartment Ownership Act, which the state government had undertaken to frame within 3 months. Now, your lordship had directed of the secretary of the BDA as to how he issued a certificate of registration when already we have decided that it is contrary the enactments.
I have filed an affidavit. And I already stopped it. And with apology, my filed an affidavit. 9/2022, man.
Ship had
My lord,
directed
there are in another point we have filed for subplot registration. They are not.
That in the meantime, my lord, two issues which are there. One issue is relating to the agreement for sale, my lord. We have already RERA in the meantime, my lord, consulted the state government. State government has notified it. I'm giving copy of that notification, my lord. The second is with regard to, my lord, the Apartment Ownership Act. What has happened in the meantime, my lord, the Taloti Association, RERA has come up with a rule, my lord, which has been vetted, and we are going to notify it, my lord, within a week's time, my lord. That I'm giving a copy of the same, my lord. We seek leave of your lordships, court, my lord, for notifying that.
We don't need to give you leave, sir. You have to do
We
what you have to do.
will, my lord. We will do that, my lord.
My lordship, they are not following the registration rules on subplot registration.
That's a different issue.
That's a different issue.
That's a
Please don't
different
mix up it.
Lord,
Don't mix it up.
Mix up everything.
Don't mix up everything, please.
You tag the case in this case.
now it is
Please
for
wait. Please wait. One after the other, the matter will be taken.
as per para.
What's happened since the last date is, first of all, this 12th September 2022. These rules have been notified. The
Yes,
amendment rules.
Yes, ma'am.
They are only the format for agreement. They have done some changes. The IGR will take a decision whether it is in consonance with RERA or not. We are not concerned with that point at this stage.
And lords may kindly see, my lord, the yesterday's communication of the Housing and Urban Development Department, my lord, to the Secretary RERA, 26/9/2022. I have supplied copy of the. May I place this, my lord?
No, this Odisha Apartment Ownership and Management Bill 2020 is what? That's different.
But that's a different thing, my lord, that with regard to this Allotee Association, since a question was raised that there is no law. In the meantime, my lord, RERA is coming up with this.
What is he?
Model Memorandum of Bylaws for the Association of Allotees. In inviting reference to the subject cited above, I am to say that the draft modalities for the formation of Association of Allotees prepared by ORERA was sent to Law Department for examination and their considered view. It may also be appreciated that in a separate stand communication, the Revenue and Disaster Management Department and IGR were also requested to offer their considered opinion on the draft prepared by ORERA. The IGR and Revenue and Disaster Management Department have already submitted their views meantime, and law departments have examined the model draft submitted by ORERA. After incorporating relevant suggestions, law department has prepared a suggestive model draft memorandum of association and bylaws of association, which is enclosed herewith, along with the draft format for notification to be issued by ORERA for issuing direction under section 37 of the RERA Act, my lord. Simultaneously, these documents have also been furnished to IGR for necessary examination and offering considered opinion to ORERA. It is therefore requested that ORERA may coordinate with IGR and notify the model memorandum of bylaws and association of allotees to address the concerns of the dependent parties in WPC number so and so for the Honorable High Court of Orissa.
Here, your lordship, I don't think the RERA and the state government are in synchronization with each other. Your lordship may see your lordship's order dated 22 June 2022 at para 3. Mr. Parija, learned Advocate General, today reiterated, my lord, order dated 22nd June, para 3, reiterated before the court that expeditious steps are being taken to have the RERA compliant apartment ownership and management bill enacted so that all pointed out by this court in its earlier orders are fully addressed. So it's a new act which has to come. Now, I don't see no how the RERA is now making SOPs for what? Unless there is an act, nothing can move forward. And the state government has undertaken that, yes, the earlier.
But what do you supposed to amend the act, Mr.
A new act is supposed to come as per their own undertaking.
But so far as the amendment of act is concerned, my lords, The instruction is that the draft communicated to Orera with a request to consult with the stakeholders and come up with a suggestion, if any, for improvisation.
No, what happened to the apartment ownership and management bill?
That bill. So far as that, it is on the works. Your Lordship, it will take some time because we are consulting with the stakeholders. We have to take the consultation from the Orera. Everything is going on. It will take some time. So far as the first part is concerned, we have complied. Your Lordship's order, first part. The gazette notification is already there and there is no objection by any stakeholders. So far as the second part is concerned, amendment of act is concerned, the matter is in the process and it will take some time. And that is the undertaking of Learned Advocate General, that is still hold that undertaking.
The issue is that only in this case that the association is not being able to be formed under the
association are not being able to form. There is a difference between an allotee association and an apartment owner.
No, they're absolutely incorrect. RERA Act says only association of allottees.
Someone may become an allotee.
Section 17 says the conveyance deed, the flat will go to the person and the common area will go to the association of allottees. Your Lordship has made extensive hearing on this. I don't know why again this confusion is being created.
Your Lordships have actually issued notice last time, have stayed a particular registration, have issued notice. I appear today, I filed a short affidavit. Kindly look at that. Actually, Your Lordship, the use of the word allotee in that RERA Act, I mean, it's not in synchronization with the dictionary meaning, but owners are covered under it. And Your Lordships, today I'm here. I'm not in quarrel with the legal position which Your Lordships are looking at. But just, if Your Lordship will just look at that affidavit, I've just forwarded it, Your Lordships. I've got it. Lordships. And would look at just my annexure 1, Your Lordships. What this association today is doing, it has come down to day-to-day living issues today for us.
We're not concerned with all this.
Lordships, no,
arrangements you have
Lordships, no, one thing I just wanted to point out is this, as because Your Lordships have issued notice and have stayed it, Your Lordships will try to understand that the real working of the words allotee, what happens is, Your Lordships, the flats today are actually in such demand, they're just like share market, Your Lordships. Allottees buy it, don't really register it. The moment the whole thing is over, they would love to sell it. But Your Lordships, when it comes to owners like us, we are to handle day-to-day business, look after the people, look after real living in that apartment. So Your Lordships, if in this interim period, if we don't have this body to look after, we do have a problem. I mean, the state government may take any number of time.
No problem. So you will have to pressurize them.
Lordships, that's why I'm here to pressurize, and it's not that we are not.
You do it outside the court, whatever you want to do.
It's not this association is outside really.
Don't expect an imprimatur. No, don't expect an imprimatur of the court. That's all. Even last time we said the same thing.
Can I just explain one thing?
Yes.
For the new rule and notified gazetted, my lord.
Correct.
Rule 10, Lordship, may kindly see that new rules, my lord.
I've supplied to Lordship.
In paragraph page 5, Rule 10 has been quoted, my lord.
The promoter on total.
Yes, may I just read it, my lord?
Clause 10.
The promoter on receipt of total price of the apartment of the plot as per clause 1.2 of the agreement from the allotee shall execute a registered conveyance deed and convey the title of the apartment plot together with undivided interest in the common areas and separately, but I'm just, this word separately, convey undivided proportionate title in the common area to the association of allottees or competent authority, as the case may be, within 3 months from the date of issuance of the occupant's certificate to the allotee. This to the allottees also is misfit actually. This to the allotee word cannot be there actually. This has to be deleted and separately word has to be taken out. These two words are actually, this is not in consonance with section 17 of the RERA Act.
No, the occupancy certificate is not issued to the allotee.
If you read the entire sentence, last to the allottees is not required to be there. Because once they have indicated about the association of allottees, this to the allottees word is...
No, it's about the date of issuance of the occupancy certificate to the allotee. That's what
yes. Comma is there. Comma is there. That is exactly...
Anyway, we don't have to go into all this now. This is not before us.
Second thing is separately, but the conveyance deed separately, it has to be executed definitely in favor of the allottee and the association of allottees in respect to their individual rights.
That can be challenged.
That
in a separate
separately word
proceeding.
is not in consonance with 17. 17 says a deed along with a one deed.
No, that deed will separately convey. That's all. Convey separately. Doesn't mean that you have a second conveyance deed.
Two deeds are not required.
No, that's what. This doesn't mean that there will be two deeds.
Yes, ma'am.
Two deeds means once agreement to sell, then
Yeah. It only says shall execute a registered conveyance deed. What that conveyance deed does will be to separately convey the interest, the title of the common areas to the association.
Separate deed, right?
It's a tripartite deed.
Anyway, you see, since the last date of hearing, the developments that have taken place are that.
Lord, before your lordship pronounces the order for today, my lord.
No, only I'm just recording these things.
My lord, on that, my lord.
Yeah, that on 12th September 2022, the Housing and Urban Development Department has notified the Odisha Real Estate Regulation and Development Amendment Rules 2022, purportedly in light of the observations in the orders passed by the court earlier. They've also apparently notified the changed draft model agreements to be executed. Paragraph. A second development that is taking place is that on 26 September 2022, the Housing and Urban Development Department has written to the Orissa Real Estate Regulatory Authority (ORERA)
recommending the model bylaws.
Recommending model draft memorandum of association and bylaws of association, along with the draft format of a notification to be issued by ORERA under Section 37 of the under Section 37 of the Real Estate Regulation and Development Act 2016.
Yeah.
Stop. ORERA has been asked to coordinate with the Inspector General of Registration (IGR) and notify the model memorandum and bylaws of association. Full stop. Mr. Tripathi, learned counsel appearing for ORERA, states that ORERA is already taking steps to comply with the above directions and will shortly be coming out with the model memorandum and bylaws of association.
Yes.
Yes, madam. Right.
My lord, may I? My lord, now that my lord has already recorded that, my lord, on 12th of September 2022, there's already a notification notifying the changes in the sample agreement of sale. And my lord, if I may say so, I'm really agree that my petitioner friend has already agreed to. So probably we are at the safe now. Now, my lord, if I may say, my lord, if I may only plead, my lord, may kindly understand for 6 months, agreement of sale along with sale deeds have been stopped registration. So, my lord, I don't intend to ask my lordship for a sale deed registration. That might still take some time. But, my lord, any agreement of sale which comply with this notification may be allowed to be registered, because this...
Who is disallowing you?
No.
You find out a single example where any of the sub-register is denying registration on the basis of this format.
No,
you
lord,
cannot ask.
May I only state...
It has come now, and now you say that no order, my responsible submission is that no order need to be passed because we have notified it. It is our duty to comply our own commitment.
My lord, that order is there already. My lord, I'm just expressing my anxiety.
It's only an anxiety. Let's see what happens.
That order is there. That order is there. That order is there. That thereafter it will be open to the ICR to instruction vis-a-vis the registration to agreement for sale. Your lordship has allowed your.
Agarwal, may I be allowed to? My lord, along with it, if I only pray, my lord, now that similarly, my lord, because see, my lord, what has happened now is for 6 years or 5 years since 2017, it was government's sample sale deed agreement of sale which was being followed. Now that it has been found wanting and in violation. Now, my lord, if your government can also come up with a draft sale deed, sample sale deed. It will iron out a lot of
preventing them from doing that.
No, my lord, it's not prohibiting them. I'm suggesting, my lord, otherwise what will happen again 3-4 months later, there'll be another challenge saying that somebody else is coming up with this sale deed, somebody else is coming up with that sale deed.
No, so even model sale deed will be provided.
Yes, that's the only
Mohanty adds that a model sale deed, model format of a sale deed to be notified to enable execution of sale deeds in that format consistent with the notified amended rules. Paragraph. He adds that the state government is already seized of preparing the apartment ownership and management bill in consultation with all the stakeholders and will eventually be bringing it about by tabling it before the assembly.
May I submit my concern, my humble concern. The last
what about your affidavit?
My affidavit is in I number 11525 of 2022 in WPC number 38186 of 2021.
1 minute. Yes.
Also, I have quoted that and paragraph number 10. I've already stalled it. I complied the order of the Honorable Court. I have not issued any other order, and that order issued also have been stated, my lords, that I have enclosed it in Annexure B by 3. There, my lords, I beg unconditional apology. It may be considered, my lords, it may be exempted. Not para 10, my lords. It appears in person of direction. My secretary is also appearing.
Affidavit is I'm not able to get it.
My apologies para treatment. No. It's order dated, order number 8.
Bhubaneswar Development Authority.
Yes. I quoted that order, my lord.
Filed in 38186 of 2021.
38186 of 2021. That the order number 8, my lords. I quoted in this order, my lords, in paragraph number 7 of my action. My lords, the affidavit is not found, man. I'm serving a copy.
How to copy the
Out नहीं जाता.
Since it was filed yesterday, perhaps it has not
come. E-filing. The order, my lords, refers to, my lords, that is at page, my lords, 4 of the affidavit, my lords. My lords, get my lords.
An affidavit has been filed by Kabindra Kumar Sahu. Secretary of the Bhubaneswar Development Authority and competent authority under the Orissa Apartment Ownership Act 1952, pursuant to the order passed by this court on 24th August 2022 in IA number 11525/2022 in repetition 38186 of 2021. So, Mr. Sahu states that Annexure 1 to the aforementioned IA, which was a registration certificate issued on 22nd August 2022, was issued single quotes inadvertently. Was issued inadvertently. Full stop. He has he has conveyed his unconditional apology for issuance of the said registration certificate. Why didn't you withdraw it now? Why didn't you withdraw that certificate?
My also permit my miles because there is a stay order. I could not withdraw. Miles permit me will withdraw. I seek leave.
Mr. Dayananda Mahapatra, Senate Counsel appearing for the BDA, seeks leave of the court to withdraw the said registration certificate. Full stop. The BDA is permitted to withdraw it.
Your Lordship, at least let us be heard before they withdraw it.
Yes. Yes. Tell us.
Yeah, Your Lordship, no, at least if BDA insist on withdrawing it, that's why I'm saying that BDA hear us out before they
For
withdraw
what?
it.
Anyway, there are orders of this court.
Your Lordship,
Their hands are tied. You see, they should not have done it when the orders were passed. Interim orders were passed with this court.
Your Lordship.
It was in the teeth of the orders of this court.
Your Lordship, there actually wasn't any order staying issuance of certificates like the one has happened in Annex 2.1.
Of staying, nobody even anticipated such a registration.
Your Lordship,
it is clearly contrary to the orders passed by the court.
If my understanding, I have gone through the orders, Your Lordship. I understand Your Lordship doesn't want it to be tinkered because of the sensitivity of the situation. And also, and I'm not even...
Let it be in conformity with the law. There's no question of such certificates being issued inconsistent with the orders of the court. Yes.
The only
as far as the owners are concerned, who have already on the last occasion also had raised before your lordships the concern for the owners who have already made
the state government is here listening to you every day.
Yes, my lord.
So just all your concerns.
My lord, if a timeline can be fixed so far as the entire exercise to be completed. Because for the last 5 months, all the registrations, everything, they're not even able to stay in their own homes, even though they're paid for it.
These are huge places, Your Lordships, which require some person in place to...
See, ultimately, your clients will be in trouble. If hurriedly something we do ad hoc and just through interim orders, all of you will be in trouble.
No, my lord, I'm not asking for the interim. I'm just
the builders will be in trouble, the owners will be in trouble.
So that
everybody will be in trouble.
No, in fact, I've gone through...
You will have nothing to convey to others. You'll be in a deep trouble.
Your Lordships, in fact, Your Lordships' concerns, I cannot have a quarrel. I absolutely agree with Your Lordships' concern. I could also imagine why Your Lordships have intervened in the matter.
Correct.
But I think the state government also has to understand that such huge number of people are staying in place.
So we will only welcome if the state government does whatever it has to do at the earliest.
Ultimately, it is citizens, I mean, and staying.
Absolutely. You say at this stage, Ms. Pamirat, who appears for the association in whose favor the registration was issued, has referred to an affidavit filed by the said association. That is the Z1 Apartment Owners Association, placing on record the difficulties being faced by the members of such association in managing the day-to-day affairs of the apartment, public building. Full stop. Unless the provisions of the law are scrupulously followed in terms of the orders already passed by this court, any ad hoc temporary solution to the problems faced by the apartment owners will only compound their difficulties and not resolve them. To stop, this has been so observed by this court in this previous order dated.
Same order, same.
Yes, orders.
Full stop.
Same order, Your Lordship.
At the same time, the court would like to
24,800.
impress upon the state government that it must put in place the new amended legislation at the very earliest to address all these concerns. Stop.
Your Lordship, I'll take Your Lordship's indulgence for 2 minutes only. Since there is a confusion arisen because of a letter of the IGR, Your Lordship may kindly take my affidavit dated 16th of August 2022 in 18799 of 2021. 16th August 2022. Your Lordship has got WPC 18799, page 10, annexure 2.
Yes.
I'll just read it. This is for the information of the registrant public that in pursuance of the orders of the Honorable High Court of Orissa and WPC so and so, registration of apartment has put on hold because of non-compliance of provisions of the RERA Act and rules which violate Section 22A of the Registration Act. RERA came into force in the year 2017. Hence, any apartment completed before commencement of RERA don't fall into this category where restriction can be imposed. Now, what is a completed apartment? Now, there is a huge chaos and confusion out there which should not have been done, because the RERA Act Section 3 says that first proviso that the projects that are ongoing on the date of commencement of the Act and for which completion certificate has not been issued, the promoter is liable to register under the Act and follow it. Now, the completion certificate has been defined that it has to be issued by the competent authority. And that competent authority is a local authority which exercises power over the land under its jurisdiction and has power to give
BDA.
Yes, BDA.
BDA.
But now the architect in the Odisha, architect issues completion certificate. And on that basis, projects are being taken out of RERA. On the basis, now architect has been held to be a competent authority in Odisha. That only clarification I need. That only on the please, sir. Please, sir. Only on the receipt of occupancy certificate, a project can be held to be completed. That is the clear definition here. Not on the architect of the builder. Even there will be only a cement structure, he will give a completion certificate. But that doesn't mean that the building is complete. It is
After
only
the completion certificate is being given, for occupancy certificate, they apply before the BDA.
Yes.
BDA authorities, thereafter, they go and visit the place. And there is a lot of procedure, SOP.
Why don't you file a...
I'll file.
So a building is held to be complete only when occupancy certificate is issued. Should we clarify that?
All conditions have been created by law.
As an officer of the court, I have to bring it to your lordship notice. This is quite sad that matters which have been pending before RERA, ORIAT, and till the Supreme Court. And my friend is aware of it. My friend is appearing in those matters where it has been clearly said the Supreme Court, my lord, has let down that the word in the Section 3 says completion. It does not say occupancy. My lord, my friend has been appearing in this. They have been said time and again that projects which have already been completed, it does not say the word occupancy certificate.
What constitutes completion?
Yes, my lord, the one he's talking about, it is actually there in BDA bylaws. In the BDA bylaws, before the regime of RERA, the bylaws clearly stated that not only my lord, the structural engineer and the architect which are empaneled by the BDA, not my lord, any structural engineer, any architect, empanel architects and empanel structural engineers. My lord, this is, if I may say so, my lord, I'm sorry to say, this is circumventing ORERA, ORIAT, everything and trying to get an order from your lordship.
Nothing, my lord.
In absence of page 16. No, my lord, because
My lord, I think we are going beyond the scope of
This
is requested not to go beyond.
I am not going. I am on, my lord, must see page 16, the clarification issued by RERA. That affidavit, page 16 only, the clarification issued by RERA itself, my lord. Only page 16. column number 10.
No IE been filed on this score.
Column number 10
is made. No IE is filed.
Completion certificate, occupancy certificate.
Whatever.
The Act 2016 recognizes certificate issued by the competent authority which exercises authority over land under its jurisdiction and has powers to give permission for development of such immovable property. As per the ODA Act, only occupancy certificate is issued by the Development Authority or Planning Authority. Hence, only occupancy certificate will be accepted for the purpose of RERA Act and not the completion certificate. This is issued by the
What relief you have sought?
This is issued by
expanding the scope of the
clarification is issued by the RERA itself. Now the IGR's letter has led to all confusion. That completion, if you are compared to the building, it is outside the purview of RERA.
Seeking some direction.
So your lordship say
instruction.
Only clarify that buildings
argument and you will explain.
I don't know. Pass on. The state government is only buildings which have received occupancy certificate.
Your
said to be complete.
For an affidavit. Your lordship has rightly called for an affidavit.
Yeah, let's
it is
call for
file
an
an affidavit.
You see,
An architect cannot, my lord, hold it.
you see, Mr. Mohit Agarwal on a counsel for the petitioner. In writ petition civil 18799 of 2021 refers to annexure 2 to the affidavit filed by the petitioner on 16th August 2022, which is a public notice issued by the Inspector General of Registration Orissa. In the said notice, there is a sentence which states that open petition, any apartment completed before commencement of RERA don't fall into this category where restriction can be imposed, unquote. It is pointed out that the word single quotes completed, unquote, has to be clarified by the IGR as it can lead to ambiguity. Paragraph. Mr. Who's appearing for IGR?
IGR, yes, I am
Mr.
appealing
D.K.
for IGR.
Manfi, Leonard AG, appearing for the IGR, states that an affidavit will be filed by the IGR clarifying what was meant by the aforementioned public notice. The said affidavit be filed in consultation with the ORERA.
But lastly, if your lordship kindly give a sign of appreciation to the government for doing it within 5 months and expect the government to
all of them are saying they're not doing it fast enough.
They will say because
then let the government do the rest part of it within
They're
a
not here giving certificates. All right.
Grateful, my lord.
All right.
My lordship, my
Where
lord
should
is
we now
giving-
list it? Where should we list it? It all depends on you now. Mr.
No,
Mohan.
because, my lordship, because major part is over. We have already what Mr. Mohanty was
No,
saying.
till they all are registered and they get registered sale deeds, it's not over for them.
I ask you, your lordship, that nobody will stop the registration of the agreement for sale, which is coming with a new format, this model format. So Mr. Mohanty should not be so anxious.
Mr. Mohanty states that all sale deeds, which come-
agreements of sale.
agreements, sorry, all agreements for sale which comply with the new format as notified will be registered.
Right.
My lordship, my
Grateful.
petition was something different about the registration of subplots without any approval of layout approvals and RERA approval.
I think he is saying about 70, 71 and 72. 3 items. Nahin? Item. Which item?
They were connected.
Connected.
Connected item. I have to file counter affidavit in that.
Okay, in those connected items, 71?
70, 71, 72.
70, 71 and 72. All right. Notice has not been issued in these.
No notice.
Notice has been issued.
Has been issued. Defects have still not been cured. We say, Mr. Mohanty state that he'll be filing a reply in these 3 petitions within 4 weeks. Rejoined before the next date. Defects also be cured in the meanwhile.
23rd November.
Right.
We'll file counter.
May I primarily personal appearance of the secretary may be dispensed.
You say the personal appearance of the apology tendered is accepted and the personal appearance of the secretary BDA is exempted. So we'll have done 24th November. 24th November. All right.
The phrase petitions which have come, my lord and friend can serve copies on me.
Right, right.
Grateful.
Supplementary list past or matter item number 17. Item 17.
Yes, my lord. So, my lords, I am in 17. Can I pray, my lords? I am not well, but in spite, since your lordship directed, I came.
Yes.
Can it be taken?
Having come, just tell us what the matter is about, sir. Since you have come all the way, just tell us what the matter is about.
My lord may have a look to the order passed by the London Single Judge.
Yes.
That will be on page 110.
Yes.
We approached the London Single Judge.
Yes.
Challenging the order passed by the insurance
ombudsman.
Yes, madam.
Correct.
And the provisions of section 45 of the Insurance Act prescribes
yes
that whenever any, your lordship can come to straight page. $114.
Yes.
The Honorable Single Judge took the view as if the insurance was of a medical insurance, medical claim. Under the LIC, my lord, there is no provision of medical insurance claim.
Right.
And therefore, my lord, can come to my lord at page 112.
Yes.
After hearing the London Council for the last paragraph.
Yes.
Petitioner and on perusing the materials available on record and also the impugned order passed by the insurance ombudsman by the Annexure 12, it is to be considered whether there is any suppression of fact by the deceased life assured so as to disentitle the opposite party to get the benefit of the award as ordered by the insurance ombudsman at Annexure 12. Consider as what the scope and ambit of the life insurance. My lord has already given some indications what the life insurance covers, etc. Then your lordship can come to page 114. That is the gist. It is, my lords have taken 6 conditions of the insurance. That is, it is a contract upon human life. There need not be an express provision for that the payment due date and the provision. The contract provisions of payment or lump sum with money, the amount, etc. Keeping in view of the above parameter, let this court consider this case. Present case, the deceased life is assured, submitted for proposal for rupees 10 lakhs and paid the minimum premium of the life insurance until her death. The life assured had been paying the premium amount without any default. The contentions raised that the policy of the repudiated invoking the provisions of section 45 of the Insurance Act 1938, which states that the policy is not to be called in question.
Sir, have you made the payment or you have not made the payment?
My lord?
Have you made the payment or you have not made the payment?
Made a payment for within, my lord, the policy continued for 1 year, 10 months only.
Sir, the single judge gave you 50 time to make payment.
This
page 117 top, sir. Please come to 100.
Top.
Rather, this court directs. Please read that.
Yes, my lord.
Please read it, sir. Kindly read it.
While pertaining to the case, this court.
No. Above that, there are 3 lines.
Passed by the insurance ombudsman, rather this court directs the life insurance company to make payment of the dues to the opposite parties within a period of 15 days.
Have you made this payment?
No, my lord.
Why not? There was no stay. Is there a stay order passed by this court?
No, my lord, there is no stay.
Then how do you deny payment? You were asked to make payment within 15 days. It's 7 years now. We take a very serious view of this matter. You're LIC, right?
Yes, my lord.
We take a very serious view of this matter. On what basis do you withhold payment? There is a binding order for High Court, correct?
Yes, my lord.
How do you not make payment? First, you make payment, sir. What is the amount due?
My lord, the amount due 10 lakhs, my lord.
First, make that payment, sir. Show us proof of payment. It is unfortunate that the appellant, Life Insurance Corporation of India, has, despite there being no stay of the impugned order of the learned single judge, requiring it to make payment to the respondent within 15 days of the date of the judgment, not made the payment till date. Full stop. In other words, for the last 7 years, the LIC has, despite there being no interim order in its favor, denied payment of the sum of rupees 10 lakhs to the respondent. To settle the death claim of the life assured. Full stop. Paragraph. The court directs the LIC to first comply with the impugned order of the learned single judge straight away if it wants to be heard in this appeal. Full stop. The payment will be made not later than October 2022, and such payment will be placed on record on the next date. List on 2nd November. Why are there two matters here?
Well, probably the second matter is the writ petition itself.
Oh, this is disposed of. All right. So we'll call it on 2nd November, sir.
May I pray one thing, my lord? I'll make the deposit in the registry.
No, sir. Please, please, please. I'm making it absolutely clear. We'll haul up people for contempt. Please, if you wrongly advise them, I'm making it very clear through you. We will not tolerate any further disobedience of the court's order.
This is not my advice.
Yes.
17. My lord, it is 2nd November.
The matter was listed yesterday when a passover was sought on behalf of Mr. Jagavanta Sahu, and yet none appeared when the matter was called out on the second call. Full stop. Today, again, the matter was listed in the interest of justice, and again, Mr. Sahu does not appear. Full stop. This court is therefore constrained to appoint, to request the Secretary Orissa High Court Legal Services Committee, bracket OHCLSC, to assign a panel counsel of not less than 10 years experience to appear for the appellant in the present case. The registry will supply to the Secretary OHCLSC a complete set of the papers to enable the Secretary to hand it over to the said panel counsel, who will appear on the next date. Full stop. The name of the panel counsel will be shown in the cause list. Full stop. List on 30th November.
Item number 84.
May I please? Here, acted like this, Miller. The respondent number 3, writ petition before this honorable court before honorable single judge, was appointed as a librarian year 1986, 3/30/12/1986. Since he had no appropriate qualification, he has granted some time, 1 year time to produce the certificate. After he joining, he left the service. He's gone unauthorized leave for 5 years. And then 5 years he came and give the joining report. His services was terminated and he approached the Learned Tribunal, Education Tribunal. And where there is no prayer for back wages, no pleading to that effect. And Learned Tribunal, your Lordship may see, page 18 for the Learned Tribunal. Page 18, from the bottom, may I read 4th line. I further hold that, your Lordship got it. I further hold that the case is barred by limitation for having been filed after the stipulated period of limitation of 1 month, but non-joinder of the said Kapileshwar Das as a respondent. In this case, the claim of the respondent number 1 and 2 cannot be entertained. That apart, the present appeal does not appear to be contended by the respondents for the reason that the approval of the refusal order thereof has not been communicated to the parties within the period of 3 months as required under the section 10A2 of Orissa Education Act. With the aforesaid observation, the appeal is accordingly disposed of without cost. However, the governing body would be at liberty to proceed afresh in seeking prior written approval from the respondent number 3, terminating the service of the appellant, because Annexure 1 shows that order of termination of the appellant was passed with retrospective effect, which is illegal and recognized in law. And in other words, while the resolution was passed on 25/2/2001, the services of the appellant was terminated with effect from 29/9/94 by Annexure 1. That order, the clarification in the next order, he clarified his order. The tribunal clarified his order. Your Lordship may kindly see. Page 21. 2. I clarify the points as follows. I have held in clear terms that the appeal is barred by limitation. Hence, I have virtually dismissed the appeal. Though I have not used the word dismissed, the observation that I have given liberty relating to the proper prior approval is only a pious observation and not a direction. The prior order has not been challenged by anybody, neither the respondent number 3 nor this particular present order was challenged without any praying for back wages or to that pleading effect. The Honorable Single Judge, your Lordship may kindly see that, directed quashing the both orders, page 36. The first order has not been challenged by anybody. Page 36. Thus, while setting aside the impugned order Annexure 3 and 5, 3 was the original order, 5 is the second order. This court directing for reinstatement of petitioner to the post of librarian forthwith, following the decision of the Honorable Apex Court referred to herein above, also directs the opposite parties 1 and 2 to pay the petitioner his entire back wages from the date of submission of his joining report, 5/11/1993, along with interest at the rate of 6% per annum. Although,
Same question, sir. You implemented this order, or you did not implement it?
No implementation is not yet implemented.
Why, sir?
No, after filing, they are not also
all self-granted stay. Only in Orissa High Court it happens, sir. Judges are all redundant. Whether we grant stay and all doesn't matter. When party files, the party will give themselves a stay. And even your opposite side counsel have signed in labor matters also. They're very happy with this understanding. Some workmen's wages are due. Management files writ petition, no stay granted. Management has granted itself a stay. And the workman also accepts it. It's very peculiar to Orissa High Court, sir. The minute an appeal is filed, stay is automatic. How is that?
There is, the Lordship kindly see, the original order has not been challenged.
I am asking you some other question. You are not diverting it.
No. I have given the answer. No, not yet paid.
So when are you paying? Let us next question. Since that stay, the so-called self-granted stay is vacated.
Thereafter,
Let's now talk about your complying with some order.
The appellants now not responding to our letters even.
Who's the appellant?
The management, the governing body of the college. Yes, I have sent the letters. They are also not responding our letters. That the petition is coming for hearing.
Then we'll dismiss the appeal. If this is the attitude, then why are we bothered? Counsel to the appellant says that despite his writing letters to the appellants, they are not even responding to him. The court finds that despite there being no stay order of the impugned judgment dated 24/2/2016 of the London single judge, it has not even been implemented by the appellant. In the circumstances, the court sees no reason why this writ appeal should be entertained. It is dismissed. Yes.
My presence may be noted. And for the opinion number 3.
All right.
Supplemental list for hearing item 91.
My lord, the appellant and the deceased are husband and wife, my lord. The prosecution story is, my lord, that they had quarrel between themselves at times, my lord. For this appellant is a laborer, my lord, in the colliery. For scanty income, my lord, she was not in a position to manage the house. Therefore, she was also always had a quarrel with her husband, my lord, the present appellant, my lord. The first, my lord, they actually, my lord, on 22nd July 2011 at 8 a.m., my lord, the informant lost a FIR that stating therein that the previous night, my lord, the husband and wife had quarrel, my lord. And it is admitted fact, my lord, he has beaten her, my lord. Thereafter, in the morning also, my lord, there was some quarrel and he left the house and the appellant gone away, my lord. After some time, when he came in to the house, my lord, he saw his wife, my lord, deceased, hanged with her sari in the house, my lord. Then he called the neighbors and showed, and by that time she was dead, my lord. Thereafter, my lord, he also took her to the colliery hospital, my lord. There they have declared that after death they have brought the body, my lord. And first of all, my lord, the case was registered under 306 IPC, my lord. After investigation, my lord, it was turned to 302, my lord. There was, my lord, the prosecution has examined 20 witnesses, my lord. According to the trial court, my lord, PW 4, 6 and 9 are vital witnesses, my lord. I am placing, my lord, PW 4 from the paper book, my lord. He's an independent witness, my lord, PW 4. PW 4 says, my lord, I know the informant and the accused. I also know the deceased who died about 1 year back. The accused had married the deceased about 8 to 10 years back. I do not know how she died. I do not know anything regarding their matrimonial affairs. My lord, in cross-examination also, my lord, he says he's a man of good conduct, whereas the deceased was of irritating nature. The parents as well as the 3 children of the accused were the inmates of their house. Every month, the deceased used to quarrel with the accused after receipt of salary by the accused, saying that it was difficult for her to maintain the household affairs with such meager amount, for which the accused used to leave the house in order to avoid any unpleasant situation, my lord. My lord, thereafter, my lord, on some occasion, the deceased had attempted to commit suicide by pouring kerosene oil over her body, and on some occasion, she had attempted to commit suicide by hanging herself from the roof. And on earlier occasion, she had jumped into a well following a quarrel with some other females while taking water. So, my lord, before this also, my lord, she has thrice, my lord, she had attempted suicide, my lord. On that day, my lord, there was nobody in the house, my lord. There was quarrel between the husband and wife, my lord. Thereafter, he left, my lord. Another, my lord, independent witness, my lord. The trial court has said it is a vital witness. He is a scribe of the FIR, my lord. PW 6, my lord. He says, I have scribed the report as per the instruction of the Thana Babu, while the complainant was sitting in another room of the police station. After I read over and explained the contents of the report to the informant, he put his signature. By the time on my cross-examination, he says, I put my signature in Exhibit 1, the consent format was blank. I have no personal knowledge regarding the occurrence. These witnesses, my lord, the trial court said, my lord, vital witnesses, my lord. And another, my lord, 9, my lord. He is also an important witness according to the. I know the accused, this is my signature. Being asked by the police, I had put that signature. I do not know anything about this case. I cannot say who had scribed the contents of the same were also not read over to me. I was not examined by the IO in this case. My lord, in thereafter, my lord, I want to show, my lord, the post-mortem examination. Mother was also, my lord, present before at the occurrence, my lord, but she was not examined by the IO, my lord. And in the court, my lord, she says, this is Kausalya. Mother, my lord, PW 14 is my daughter, and the accused standing in the dock is my husband. The marriage was solemnized in the year 2003. After the marriage, the deceased.
What are you reading, sir? What are you reading, madam?
Happily, my lord.
Which PW are you reading?
PW 14, my lord, mother.
Right. All right. Yes.
Yes, my lord. After the marriage, the deceased lived with the accused happily for about 4 months. And thereafter, the accused started assaulting her. The deceased, after being assaulted by the accused, came to my house and lived with me for 2 months. During that period, the deceased was unwilling to come to her in-laws' house, my lord. After 4 months, I, along with mother, means the deceased grandmother, my lord. The mother came to my house of accused and found the deceased was hale and hearty. After 15 days, thereafter, one Gomati informed us that the deceased is seriously ill and not taking food. Before 15 days, my lord, when the mother of the deceased and her mother came to see them, my lord, she was hale and hearty, my lord. I have not given my statement to the IO. Whenever I deposed today, only whatever I deposed today in the court, she was present at the occurrence, my lord, but she was not examined by the IO, my lord. Thereafter, my lord, PW 15, my lord, doctor who conducted the post-mortem examination, my lord, of the deceased, my lord. There was multiple abrasions of fingernail mark seen around the face and neck. On the left side of chin also, 1.5 cm, left side chin. My lord, a faint impression present over on the front of neck, running up to left side angle of mouth of size 2 to 3 cm breadth and 14 cm length, my lord. On cross-examination, my lord, the cause of death, she says, my lord, death of deceased was due to asphyxia as a result of manual compression of trachea as well as injury to the common carotid system. Time since death was within 24 to 30 hours at the time of examination, my lord. She was sent to the hospital, my lord. After 8
Madam,
o'clock.
there is something in your favor in the cross-examination. You're not reading it.
Cross-examination, I am reading. I did not notice any finger impression on the neck of the deceased, my lord. If it is, my lord.
Carry on reading. There is something in your favor. Please
Yes,
carry on.
I did not notice any finger impression on the neck of the deceased. There is no the difference between manual strangulation and throttling. Asphyxia death can also be possible by hanging, my lord. Actually, my lord, she was.
Please read on, madam.
Yes, my lord, yes. It is not the fact that I have not dissected the belly, chest, brain, or etc. It is a fact that I have not mentioned in Exhibit 3 as to whether the deceased suffered a homicidal death or suicidal death.
This is all you have to read. You're unnecessarily adding.
Yes, ma'am.
See, the art of advocacy is don't keep adding to something which is in your favor. Come to, please read something which is in your favor and leave it at that.
Yes, my lord.
When you try and add things, what is in your favor also will go.
No, my lord.
Please come, be precise, read what is in your favor.
Yes, my lord. And asphyxia death can also be possible by hanging, my lord. And she was hanged by her sari herself, my lord.
Or we don't know that we do.
My lord, I
Yes.
have also.
That is why I'm saying don't add more than what you know. You also don't know, so don't try and.
Yes, my lord. My lord, actually, my lord, she is a quarrelsome lady, my lord.
You don't know that. This is just one version.
My lord,
Your suggestion to the mother that she's quarrelsome has been denied.
no, my lord, but before 15 days, my lord, she said she was a hale and hearty. And after
Hale and hearty does not mean happy. The words hale and hearty do not mean happy, madam. Even some words very sad can be hale and hearty.
How can my lord? My lord, I have also made one small notes of submission, my lord.
Who's Mr. Katkia? What is the evidence?
Evidence is the dead body was found in the house of the in-laws.
Hanging.
Yes.
No, the dead body is found hanging. Let's see, go back to the IO. How was the dead body found?
IO found the body of the deceased in the hospital. Rajarajagar Hospital.
No. What do they find at the spot, sir? Is there any sari by which it was hung, tied?
The doctor has clearly stated that it is as a result of manual compression of trachea.
You're jumping somewhere else, sir. Let's go step by step.
Because most of the witnesses have turned hostile in this case.
Correct. How do you construct? So what happened on that day, according to the prosecution?
It is only PW12 and PW13, the father and mother. But after getting the news of illness of the deceased, they came and ultimately found the deceased died and her body was there in the hospital. So the allegation of section 490 is very clear. So far as section 12 and evidence of PW12 and evidence of PW13 are concerned. Sorry, PW14. Father and mother of the deceased.
No, they came there much later, sir.
Yes, of course. But they have noticed some mark of injuries on her person. And regarding the presence, regarding where The dead body was found. That is not exactly, that has not come out. Because
So maybe
IVO has
498A is proved, maybe 306 also is proved, we don't know.
But plus, so far as a postponed report is concerned, and Schedule 15 is concerned, that appears plus is a case of asphyxia, not due to, hanging. It is
No, look at the cross-examination, read it.
Yes, I have seen that. It is a fact that I have not mentioned in Exhibit 3 as to whether the deceased suffered a homicidal death or suicidal death. But it is clear.
You're also, this is the whole problem, sir.
Right.
She will read only what is suiting her. You will read only what is suiting you. This is not the way to argue. I'm sorry to say this is not the way to argue.
No, of course not. Yeah.
When you have to read, you better read the complete thing.
I am reading this.
May I say one thing?
Please, please. Read the entire cross-examination.
The external injury noticed by me can be possible by self-infliction. I did not notice any finger impression on the neck of the deceased. There is no difference between manual strangulation and throttling. Asphyxial death can also be possible by hanging. Yes, Master.
You don't read the sentence.
I'm sorry, Master. It is not a fact that I have not dissected the belly, chest, and brain of the deceased during post-mortem examination. It is not a fact that I have prepared Exhibit 3 to suit the prosecution case. It is a fact that I have not mentioned Exhibit 3 as to whether the deceased suffered a homicidal death or suicidal death. But one aspect.
So she has not ruled out hanging. This is the whole problem. Usually, medical opinion clearly tells us whether it's manual strangulation or by hanging because of the ligature marks.
Yes, yes.
Here, there doesn't seem to be any such examination to tell us whether these ligature marks are ante-mortem or post-mortem. See, murder will happen if you manually strangle the person and then make it appear to be hanging, correct?
Yes, Master.
Then the ligature marks will be post-mortem. If the doctor is not sharp enough to notice that, then the crucial piece of evidence is gone.
That has not been made clear in the evidence belows.
Says hanging. PW2 is sister.
What is it?
PW2 is who?
The accused is my brother. It happens to be the brother of the accused.
How were they all roped in as prosecution witnesses?
I did not.
She says, my lord, I do not know anything about the case.
Naturally, she's her own sister. Why should she speak against her brother?
Not supported the prosecution as.
But the father of the deceased also, my lord, in this project examination, at last portion, she says, my lord, there was I have not seen any injury on the body of the deceased, nor noticed any bandage.
They are all hostile witnesses.
Yes, absolutely. The whole problem is they're all hostile.
Because they are persons from Chhattisgarh. The paternal house of the deceased is in Chhattisgarh.
No, but why were the the sister of an accused brought in as prosecution witness? Very strange. The sister of the accused, why should she be a prosecution witness? Who's PW1? Pirtu Sahu. Accused is my brother-in-law.
He's the brother-in-law.
So is he the brother of the deceased?
He's the brother-in-law.
No.
The
deceased. How is he related to the deceased then?
This is the brother-in-law of the accused. So accordingly,
how is he related to the deceased then?
Deceased happens to be his sister-in-law.
She says, my lord, I do not know anything about the case, my lord.
He must be. He must be the brother of the deceased.
No, brother of the, not brother of the deceased. It is a brother.
So why are they examining like this? What is the prosecution examining them
He's
for?
related to the accused, not to the deceased.
No. Accused is my Sala money said that. Holy na say. Sala para bracket
I was not examined with the IO. I do not know why my signature has been taken. Very poor quality of investigation and evidence. Absolutely no evidence.
Well, the sister of the accused got married to the PW1. Sister of the accused got married to the PW1.
All right. Orders reserved.
Well,
Item number 92.
May I please, Your Lordship?
Yes, sir.
My lord, this is a jail criminal law, Your Lordship.
Yes.
And offence is under section 302 of IPC, wherein the appellant were convicted.
Yes.
To undergo RI for life, and to pay 10,000 rupees.
Right.
My lord, if my lord will go through the judgment of the learned trial court, I have no case at all. My lord, kindly, by basing upon, in this case, Your Lordship, by basing upon the statement deduced by the PW number 5 and 13, though two witnesses are the co-relatives and they are one of PW number 5 is the caretaker of the deceased, and PW number 13 is the wife of the deceased, Your Lordship. By basing upon the statement of the PW number 5, the FIR was lodged and the case of the investigation taken up, and after the submission of the investigation, the case was charge sheeted, Your Lordship. Here, Your Lordship, kindly peruse the evidence of PW number 5.
So the disease is Ratna Jamkia.
Yes, Your Lordship. Ratna Jamkia. Earlier, the
decapitation of the head from the body, sir.
Yes, Your Lordship. Yes, but no eyewitness, Your Lordship. No. PW number 5 is the caretaker of the Ratna Jamkia, the deceased, and so he has enmity with the appellant, Your Lordship. And PW number 13 is the wife.
No, Sahadev Dhibar is not an eyewitness.
No, he is not an eyewitness because at the time of occurrence, while the deceased, while the appellant stays at the PW number 5, a consul is within in a house. How he will see the occurrence, Your Lordship? No doubt. He stated before the IO and before the landed court below that I have seen the occurrence within a distance place. But how it is possible, Your Lordship?
Why not?
Because he is concealing inside a house.
So what? So he's chasing, the grandfather stops him, the grandfather gets hit. What is wrong?
Thereafter, my lord, he stated after the at the time of occurrence, was even though he presumed to receive, he specifically stated that he had, appellant has assaulted on the left arm of the first assaulted a left arm by X, by means of X. Thereafter, he stated that while he was staged by the appellant in concealing a house, and little distance, he found that the appellant again came back and assaulted many of the X blows on the head of the deceased till it is separated. And thereafter, he added something, Your Lordship, by cutting after the separation of the head from the body, he cut hold by a polythene bag and took away, proceed toward the on, Your Lordship, wherein he was cut hold by the police. And further, he added that appellant was drunk the blood of the deceased, Your Lordship, and thrown some coin on his chest. Here, Your Lordship, it is
any PW4 by himself is enough, sir.
My lord, I will clarify, Your Lordship, what the PW number 4 will say. All the statements are not corroborated with all the. I'm placing, Your Lordship, PW number 4.
No, that's okay, sir. You place the. PW5.
PW5, my
right.
PW5, By basing upon it, I am stating.
Just see the cross-examination. Let's see the cross-examination.
My lord, I'm placing the only cross-examination. My lord, you're getting page number 43 of the paper.
Correct, correct. Initially, the accused was staying.
Initially, the accused was staying in the house of the deceased to take his care. It is a fact that the deceased removed the accused from his house and thereafter brought me to his house to stay with him. It is a fact that due to such dispute, there was a quarrel and enmity among myself. The deceased and the accused for the landed properties of the deceased. The ward member of first informed the local police over phone who arrived at the spot before lodging my FIR. It is a fact that first the Bonai police.
How is this informant related to the disease, to the accused? To the accused. How is he related to the accused?
Because, my lord, they are the co-relatives and the nephew. I think I heard from he is a nephew of the deceased.
What is it?
Nephew.
Putra. And the informant is the nephew of the accused.
Yes, your lord.
All right.
Thereafter, my lord, it is a fact that the Bonai police apprehended the accused and took him in a Jima of Lohunipada PS. I have lodged the FIR at the police station. I am scribed the FIR on the next day of the incident. I have lodged the FIR at the police station. Then 3 your lordship. It is a not fact that I have stated before the IO and in my FIR that the first accused dealt a blow to my grandfather on his hand and later to assault with a tangi. So out of fear, I concealed myself inside the house of my neighbors. It is not a fact that I have stated in my FIR and before the IO that I have seen the assault on my grandfather by the accused remaining from literal distance while I conceal myself. It is not a fact that I have no idea about this case, but due to our family dispute, I have lodged a false FIR against the accused.
All right. Who's the other witness?
13, your lordship. 13, your lordship, at page
55.
55.
At page 55, your lordship.
Right.
I'm starting from the examination chief, your lordship. The informant is my husband. I know the accused. The deceased Ratan Jamaica was my grandfather. There is some informant is my husband. The incident happened around 2 years back, one day at around 4 p.m. in the village. The accused is uncle of my relation. I, myself, and my husband were staying in the house of deceased, as he had no male child. There was frequent quarrel between my husband and the accused due to land dispute. On the very day of the incident, the accused was quarreling with my husband for land dispute. At the time of such quarrel, the accused took attempt to assault my husband with an axe. I then raised halla at the spot. My husband started running away from the spot while the accused chased me to assault with that tangia. At that time, deceased Ratna rushed to the spot on hearing halla. The accused then dealt a heavy blow with that axe on the right forearm of the deceased. Thereafter, your lordship, while Ratna sat on the ground, at that time the accused successfully dealt 4 to 5 numbers of blow with that tangia at the neck of deceased Ratna, as a result of which the head of the deceased was completely cut off from his body. Then the accused kept the head of the deceased in a polythene bag and started running towards the Bonai. Thereafter, the local police arrived at the spot. At that time, the committing the crime, the accused has wandering with the tangia to kill others at the spot. Here is something, your lordship. Then after the cross-examination, your lordship. The deceased Ratna was the uncle of my father.
There's nothing in this cross-examination. This is a good witness for the prosecution.
No, my lord. My humble submission before lordship is the wife of the Peter number 5. And they are with the deceased, your lordship. And all the incident which is stated in the FIR, not corroborating the statement of these 2 witnesses, your lordship. FIR is something saying something, and they are saying something. There is a dispute between the parties also. There is a land dispute is pending. They are admitted both the year. My lord, there is no eyewitness at all. Because
what are you saying, sir?
No, my lord.
Don't repeatedly say that. Anyway,
I'm sorry, my lord.
My lord, we are sorry.
I'm trying to.
I know, but don't therefore say there's no eyewitness at all.
No,
There are two eyewitnesses whom you say should not be believed.
They are stated before the learned right court, I know.
So the way you should argue is there are two eyewitnesses. Please don't believe those eyewitnesses.
Yes.
Don't argue that no eyewitnesses.
Your Lord. Because both the witnesses
are related.
So highly interested witness.
All right.
For the prosecution, your Lordship.
All right.
Besides this, no any independent witnesses are supporting the case of the prosecution, your Lordship. My humble submission. The prosecution failed to establish case beyond all.
All right.
And at a spare of moment, your Lordship, sudden aggressive provocation, the occurrence taken place, and up to 5 assault.
The head itself is severed. I don't know what you're arguing, sir. When the head is severed, you're arguing 304.
304 part 2 may be come.
So the head being severed.
No, man.
You please find out in case law. It will be very interesting to know when somebody severes somebody's head, 304 part 2 is applied. This is a new criminal law we are learning.
No.
Yes.
All right. My submission before Lords.
All right. Yes.
He will be acquitted, your Lords.
I'll start with the IO because the IO, my lords, apprehends the accused with the severed head while he was.
I know that's all right. The only point he's making is both of these eyewitnesses are related. Therefore, they're interested. They had a previous land dispute. Therefore, they're falsely implicating him.
Please, but nothing has come in the cross at least, which
no, they only can give suggestion. Both witnesses they have suggested.
Yes, and both have said, Millards, what is
correct.
Happened.
But what more can they do? They can only give a suggestion.
Please, Millards. And Millards, PW2 is the only independent witness, so to say, who has seen. If I may read PW2, Millards.
Yes.
Page 38, Millards.
I don't know.
Start with the. I know the informant and the accused in the village. I know the deceased in the case who was my villager. On the alleged date of incident, I, along with others, had gone to the house of our neighbor Loknath to witness a TV show. But at that time, there was current failure, so I came back to my house.
It's all very unconvincing. A dark night, 100 feet and all he's seeing.
Apart from Millard's him, there are just two eyewitnesses, 5 and 13. Millard's the head was severed. The head, the IO brings the head.
All right.
So
orders reserved.
Pardon, my lord. 1 minute, my lord.
Yes.
I beg pardon for that. My lord's leave. My lord, I have not placed the statement of the doctor, your lordship, wherein doctor specifically denied in his cross-examination that here the memo, material of offence, was not produced properly. It was not seized articles, your lordship. He is not mentioned in the for the several times it was cut down by the ex, your lordship.
May I bring to your lordship's kind notice, Lord, 2 death references are pending since 2019.
You tell us, sir. We are ready to hear everything. Right. Give us the numbers. We list it.